This forest matter twice and three.
That 41 rule.
Yes, yes.
Lekha. Item number 6. Mr. A.I. Uddin, Learned Counsel for the petitioner. For the petitioners, on instruction submit that both the petitioners, Nam likhi diwa Muhammad Abdul Aziz Arwezonasa, during the pendency of the proceedings do you have the dates?
Date I have not.
Have passed on. Also, he submits that the matter accordingly stands abated. Full stop. Prayer is not objected to by the Learned Counsel for the view of the above position. The present revision petition stands closed on being abated.
Oblige.
I may apply for listing my lord.
When? Fail. Fail.
No, my lord. Criminal.
Fair, my lord, criminal petition.
All
Oblige, my lord.
mention memos, give it to her, she will give the dates. Like in a DD, huh?
Mention item number 22. I said,
Why?
this unit is out of station. Is-
This was heard and this was fixed today. You are
Yes.
40?
I am for the senior as the I'm for the respondent.
Hmm. He's not coming back for the whole week.
Oh, my lord, this week, Friday or
A prayer is made on behalf of Mr. S. Dr. Learned Senior Counsel, appearing for the respondent for an accommodation in the matter on the ground that he is out of. Prayer is not objected to by the Learned Counsel for the petitioner. So accordingly, register it to list this matter again on Monday. Yes, Ms. Alam.
One of the appellant has expired, lords. There are 11,
Nine are left.
altogether 11 are there.
What do you say?
And 8.
Hmm.
Your lordship to the particular.
Has the informant joined the profession?
Lordship, no.
No. Then
Lordship, I'll take you, altogether 13 witnesses were examined. 13, Lordship, PW 2, 4, and 5 were considered.
they are the eyewitnesses,
They
the
are the
witnesses.
victims, alleged victims, Lordship. Witnesses, they did not support the prosecution story. So their statement was not considered. Only the interested, evidence of interested witness.
But the witnesses' evidence also is corroborated by the doctor's medical.
But they are not consistent with the manner they have narrated the incident. PW 2, 4, and 5, they are not consistent.
The incident on 2 days.
Lordship.
Incident
Incident of
occasion
2 days.
2 days.
And there is a defense story, or by the other witnesses, they have said that there was a exchange of money between the father of the
Not an exchange of money. They say there was a compromise.
compromise. Yes, village Bichar was there.
There was a compromise and the case was not to be proceeded with.
Yes.
But the informant, she proceeded with the matter.
3 of them, they were taken into custody during the investigation. They were in
No, three. Bhojo and 2 others were taken into
Bhojo,
custody. Others surrendered.
Kirtan Boro and Vipul Boro. They,
Others surrendered and they were continued with. Punishment is
1 year, 1 year, maximum 1 year, that is under 325, causing voluntary.
1 year for 2 offences, 350, 325 and 5062 149.
Yes, yes, sir.
Everything is clear. But the doctor has said it's simple in nature.
Simple injury.
Where do you get that?
No, PW, most probably he was PW7 doctor. Yes.
One 148, 341, 354 acute.
325 होता है.
325, 323, and 384.
Fuleshwari Boro was injured.
She was also, her clothes were torn
Yes.
and she became unconscious, unambulatory.
Like his persons were incorporated by way of sweeping statement. No act was attributed.
The only thing I find here is actually who has
Assaulted the
assaulted, that has not been attributed. It's a gang. Bicycle was taken that he went to ask. There was a 5,000 rupees loan. So everything
That loan
contributed.
and mortgage and land. There was some dispute in the car.
But you have not exhibited all those
those
materials.
documents. Well, because PW's most probably 8 to 12, they have admitted that thing.
No, admitted, but the factum has not been brought on record by the in 313 or by adducing defense evidence. You have not brought those. Incident is of 28-2.
8.
Okay. Heard Mr. G. Alam, learned counsel for the petitioner.
I'll submit the death certificate issued by
No, tell me who has passed away.
Devananda Boro, appellant number 3, Lordship.
Just so. Petitioner number
3, Devananda Boro.
Devananda Boro. Then
Only one.
only one has
One,
passed.
other 10 are there. Ah,
27-11-23. Also heard Mr. MP Goswami, learned additional public prosecutor appearing for the state. Mr. G. Alam, learned
yes.
Z. Alam, learned counsel for the petitioners at the outset has submitted that during the pendency of the present proceedings, on pending proceedings on 27-11-2023, the petitioner number 3 has passed away and accordingly submits that the present petition, insofar as it concerns the petitioner number 3, stands abated. Full stop. The position is not disputed by Mr. MP Goswami, additional public prosecutor. Accordingly, the present writ petition stands abated in respect of respondent number 3, and the present order is confined to the other petitioners only. Full stop. The present petition, criminal revision petition, has been instituted, assailing the judgment and order dated 12/9/2012 passed by the learned session judge Udalguri in criminal appeal number 5 bracketed D-U bracket over oblique 2012 in connection with 12, dismissing the appeal and thereby upholding the conviction and sentencing of the appellants herein by wide judgment dated 12/7/2010 passed by the learned judicial magistrate first class Mangoldoi in GR case number 179/2008 under section 148/352/325/323/506 bracket Roman 2 bracket over /384/149 IPC. The prosecution case in brief is that the informant, Mridusmita Boro, had lodged an FIR on 28/20/2008 inter alia alleging therein that on 23/2/2008 the present petitioners inter alia alleging therein that the petitioner number 1 herein had borrowed from her brother Dilip Boro his bicycle, and on the next day when her brother asked the petitioner number 1 herein to return the bicycle, he refused to do so, which led to a quarrel ensuing between them. It is further alleged that on 24/2/2008 at around 7:30 p.m., the petitioners herein, including the petitioner number 3, armed with deadly weapons, came to the house of the informant and assaulted her mother, Fuleshwari Boro, father Harishchandra Boro, and brother Dilip Boro. Also, it is further alleged that again on the next day morning, that is on 25/2/2008 at around 10 a.m., the petitioners, herein, had again come to their house and had assaulted their mother, Fuleshwari, by undressing her and confining her in a room and torturing her. It was also projected in the FIR that the petitioners, herein, had taken her mother, Fuleshwari, Harishchandra, and Dilip in a handcart to a vacant field and had again assaulted them. Also, the informant further alleged that the petitioners herein, had obtained the signature of her brother Dilip in a blank paper and threatened them with dire consequences if they reported the matter to the police. Full stop. Subpara. On receipt of the said FIR, the same was registered as Paneri PS case number 14/08 under section page 43 underlined portion. Full stop. On completion of investigation, the police laid a charge sheet against the present petitioners under section B, underline B, upper to A. Also, the subpara. The learned trial court, upon examining the materials upon appreciating the materials coming on record, framed a charge under A to C. So, the said charge on being read over and explained to the present petitioners, they pleaded not guilty and claimed to be tried, a trial accordingly ensued. Subpara. During the trial, the prosecution examined 13 witnesses and thereafter the statement of the accused person under section 313 came to be, 313 CRPC came to be recorded. Also, the learned trial court, on conclusion of the trial, on appreciating the evidences coming on record, was pleased wide judgment dated 12/7/2010 to convict the appellants, the petitioners herein under section 48. Well, also, and they were thereafter sentenced for the offences as held to be established against them in subpara. The petitioners hearing being aggrieved by their conviction by the learned trial court, assailed the judgment dated 12/7/2010 by way of instituting an appeal being criminal appeal number 5 bracketed D-U/12. The learned appellate court, upon appreciating the evidences coming on record, was pleased by judgment dated 9/7/2012 to dismiss the said appeal and uphold the conviction of the petitioners herein, by the learned trial court. Also, subpara, being aggrieved, the petitioners have instituted the present proceedings. I've heard the learned counsel for the parties and also perused the materials available on record. The learned trial court, upon appreciating the evidences coming on record, was pleased to draw the following conclusions. Page 40 is a certified copy for A to A. Having drawn the above conclusions, the learned trial court convicted the appellants herein under section D, mark D, page 48. So on their such conviction, the petitioners herein were sentenced as follows. E to E. 48 really has. Also, the said judgment on being assailed before the appellate court. The appellate court wide judgment dated 9/7/2012 upon appreciating the evidences coming on record. As well as evidences coming on record. Was pleased to draw the following conclusion. Para 19, 21, 22, 24. So I have carefully perused this court has carefully perused the conclusions drawn in the matter by the learned trial court as well as by the appellate court. Also, on a close perusal, this court finds that the conclusions are so drawn basing on the evidences coming on record and no infirmity thereon is found by this court. Also, accordingly, the conviction of the appellants herein under section D would not mandate any interference. So, this court further notices that the learned trial court as well as the appellate court, while proceeding to sentence the appellants herein, had not considered as to whether the petitioners would be entitled to the benefit under the Probation of Offenders Act 1958. Also, this court finds that the incident involved in the present the offense was committed by the petitioners herein on 23/2/2008, on 24/2/2008 and 25/2/2008 25/2/2008. Also, it is found that more than 17 years have lapsed since the commission of the offences by the petitioners herein. This court also notices that the petitioners herein have been during the last around 18 years litigating the matter, initially before the trial court, thereafter before the appellate court, and presently in the present proceedings before. Also, considering the long lapse of time occasioning in the matter, this court is of the considered view that the petitioners herein are entitled to be extended with the benefits flowing from the provisions of the Act of 1958. So at this stage, this court also notices that the petitioners number, the Bhojo, they are number one. What are the three people who were behind the bus?
Number 1, 2, and 10.
Petitioner number 1, 2, and 10 were initially arrested and were kept in judicial custody till they were granted bail on
17/4/2008.
17/4/2008 by the trial court.
Right.
Also, in view of the above position, this court is of the considered view that while the conviction of the petitioners would not mandate any interference, they be not sent to, they be not be ordered for undergoing the sentence of imprisonment as ordered in their case, and they be extended with the benefit under the Act of 1958. So However, this court has not interfered with the sentencing of fine as imposed upon the petitioners herein, comma, excluding the petition number 3, comma, by the learned trial court. Baki hini amar disclosed of.
Deeply.
After 17 years, don't expect they have suffered enough.
That's all.
Hmm.
Of 2008, my lord.
Hmm.
F charge sheet was also convicted under section years 10,000.
How long were you behind bars?
What, my lord, in the paper book, but think that I was so badly beaten. Grade 4 employee of APSC.
Okay, you have
spinal
taken a
cord was
plea.
broken.
You have taken a plea that you wanted to lodge an FIR, but you were prevented from doing so. But why did you not take it further? In the police station, it was prevented. Why didn't you go before the SP, before the?
Exactly. Legally, your lordship is very much correct. But thing is that he was found in a senseless condition and he remained in hospital for long time. His spinal cord was broken till date. He is unable to hear even, my lord. And till the robbery,
Spinal cord broken and the hearing, what is the connection?
my lord, hearing, they were beaten not only there in entire.
And what happened to his spinal cord?
Kindly see the records, my lord. Medical records are also there, my lord. And there are serious contradictions. There is not a single material to come to a conclusion beyond reasonable doubt that he is guilty of this. Self contradictions are there. The main victim
The
is saying,
victim statement is very clear. Victim statement is very clear that the boy had done something bad with her and she was bleeding. Stains were found in her undergarments. I don't know why this was not sent for FSL or something, be that as it may. Medical evidence corroborates swelling. The IO's evidence says that the seized undergarment had bloodstains. What more is required? 5-year-old girl,
but my lord, the boy, my lord, is a aged person, my lord.
23, 24 years at that point of time, yes.
No, my lord, he's already retired, my lord, from job.
retired?
Yes, my lord, retired from job around 62.
Okay.
So he was also with his family, my lord.
He was that evidence is not there, that there were people in his house at that point of time. There is no evidence.
But kindly,
And the evidence of the
first of all,
mother is,
my lord, first of all, come to the, my lord, PW1 Puja's last line, my lord. Cross, in cross. I'm not sure more than.
এই যে জব্দনামা মই চহী কৰা নাই, কিন্তু এইখন মই লিখিছিলো জব্দনামা আমাৰ অফিচত বনাইছিলো। আদালতত মই তৈয়াৰ কৰা জব্দনামা চিন কৰা নাই, মই চিজাৰ কোনো বস্তু আদালতত অনা নাই। আদালতত জব্দকৃত কাঠ কাৰণে লোকেল ইনস্পেকশন ফেয়াৰ দিয়া নাই। But on next day again, during the further cross examination, he says that Caesar list খন মই স্পটতে বনাইছিলো।
there is a contradiction there. Yes, Mr. Sharma.
Around, my lord. My lord, lordship may modify the sentencing part, my lord.
That's your alternative way. What are the sentences given, prescribed?
Sentences, my lord,
25 sections are 25,
24, 25, 35, and 41.
24, 25.
35, 41. Sentence is, my lord, for 20 months imprisonment, my lord. For 25, imprisonment for 1 year. 35, imprisonment for 1 year. Or 41, simple imprisonment for 1 year.
So all are with or.
Yes.
Let us just see the penal sentencing.
Page number 32.
Okay, we are modifying, we are upholding the conviction, but we are modifying the sentencing. We are increasing the fine amount. No imprisonment. We'll pass the order in the second half. Second case also same,
Same, same, same,
same FIR.
same FIR.
Okay.
Highly obliged.
দুটা বজাত দি দিবা ঠিক। Yes, Mr. Sharma, has he undergone the sentence? You were supposed to receive instruction. Mr. Goswami. You try, we'll take it up at 2. Thursday. Mr. MP Goswami, learned public prosecutor for the state, submits that he will place the clarifications as sought for by this court wide order dated 16/9/2025 on Thursday. Friday. That whether he is still alive or gone. Vote. The present appeal was instituted by the appellants Mukunda Madhav Borman and Nor Narayan Sharma, assailing the judgment and order dated 19/11/2013 passed by the learned special judge Assam in special case number 2/2009, convicting the appellants and appellants under section 409 read with section 13 bracketed 2, comma, section 13 bracketed 1 bracketed C of the Prevention of Corruption Act 1988 and sentencing them accordingly. Also, this court on 17/9/2025 was informed by the learned counsel for the appellant that the appellant number 2, Narnarayan Sharma, had passed away on 7/5/2021. Also, although it was further projected that it was also learned that the appellant number 1, Mukunda Madhav Burman, had also passed away. However, confirmation thereof was not available. So accordingly, this court, while order dated 17/9/2025, had required Mr. MP Goswami, learned additional public prosecutor, to receive instructions in the matter. Today, when the matter has been taken up, Mr. Goswami has placed on record the written instructions received by him from the SP, Senior Superintendent of Police, Directorate of Vigilance and Anti-Corruption, Assam. Written communications dated 24/10/2025 received from the Senior Superintendent of Police, Directorate of Vigilance and Anti-Corruption, Assam, wherein it was projected that on inquiry, it was confirmed from the family of the appellant number 1 that the appellant number 1 had expired in the year 2018. Also, as both the appellants herein having expired during the pendency of the present proceedings, comma, the present appeal stands abated. Also, accordingly, the present appeal stands closed on having been abated. The copy you place a Xerox. A copy of the communication dated so and so, furnished by Mr. MP Goswami, additional public prosecutor, is kept on record and marked as X. Yes. Your name?
Atri, Lordship.
Eh?
Atri, I am not on record, Lordship.
Oh. Who is in Lex? DK? AK? DK. Heard Mr. DK Bachchan. Huh? So heard Mr. MP Goswami. Huh? Done.
Lordship, the divisional petitioner was convicted 138 of an act for a period of the extent of 19 lakhs. Section 357(3).
Hmm.
The appeal that was modified amount remains same, compensation amount same. That was converted to imprisonment till raising of the court. This revision petition is preferred. Here in this case, I like to point out only there are not much these things. As regards to the exhibit 2 and 3, going to be the Sora check for an amount of rupees 3 lakhs and 3,51,000, 15 lakhs 81,784. If we add up both this amount, it comes about 18 lakhs 81,784. That is exhibit 2 and 3.
The checks.
This checks. Whereas by exhibit 6, demand notice was shown. Exhibit 6, demand notice, the amount demanded was 18,91,074, which is not a check amount. My case is on this. That means the complainant case, what his checks were dishonored by these two checks, exhibit 2 and 3.
amounting to amounting total amount of rupees 18,81,784.
Hmm.
But demand was made as against 18,91,074. This is not the said amount. Therefore, this finding is given by both the courts below, trial court as well as appellate court, is not sustainable under section 138B. What 138B reaches, and I have number of judgments. There are about 10 judgments on Honorable Apex Court. I lay before this Honorable Court 2 of the judgment, important judgment, passed recently.
Let us see the complaint.
Then is copy. Complaint, there is nothing much. There was some business. This man was soon to be given, he is a subcontractor. Petitioner was a subcontractor under the main contractor, NEM, this thing. Thereafter, he assigned the job to this complainants for partnership business. The complainant is the one of the soon to be one of the partner, but the partnership business partnership deed was not served. Therefore, the another point is that whether this complainant is authorized, can he file this complaint or not? Therefore, my submission, let us come to the lordship that exhibit 6. What exhibit 6 says?
Just a moment, let us see the complaint first.
Lordship. Complaint.
Hmm?
We have not, the complaint is not.
No, not been raised, annexed. Will be on the records, so let's find out the records only. Yes. 1893/2009.
Lordship.
There was his Borkoto. Okay, the check value is 3,000,
18,000, check value is 18,000, 18 lakhs 91,000,
81,000.
81,784.
So he has only claimed
He claimed 81 lakhs 91,074 by 2 checks.
2 checks is 18 lakhs something.
18 lakhs 81,000.
Huh. So he has claimed the check amount only.
No, he claimed more than that.
Where do you get that?
That is just, let us come to the demand notice. Exhibit
Okay.
6.
Exhibit 6. Demand notice dated
Demand notice dated, that was 2/3. It also, it is not.
24/3.
24/3.
Hmm.
Exhibit 6. Here, let us come to the para 1. Para 1. Exhibit 6, that you have placed that fight order that so and so apply of certain sound requirements, enforcement system worth of rupees 23 lakhs 81,000 so and so. After approving the estimate fight so and so on your supply aforesaid sound system at Rabindra Bhavan, Guwahati. My client accordingly supplied the said requirement and item so and so a bill of rupees 23 lakhs 91,074 and which included additional product not included in the requirement. The amount of rupees 5 lakh was paid to my client by advance and residual amount of rupees 18 lakhs 81,784 was paid in check to be credited to my client's account with a verbal assurance to pay additional amount of rupees 9,290 rupees. This is the actual additional amount they have added up with this.
No. What has happened here is there is a agreement. It was exhibited as A1.
Yes, sir.
In that agreement, there is a particular items of work
Lordship.
that was subcontracted to
Lordship.
you.
Oh.
That worked out to around 18 plus 5, 21, 22 lakhs odd,
23
something,
lakhs.
something
Yes,
odd.
yes,
Then that was supplied, for which you gave him a check, two checks,
two checks.
and some cash.
Yes.
5 lakh cash and two checks. Advance, be that as it may. 5 lakh cash and two checks. Then there was a change in the scope of work, which was awarded to you.
Lordship.
Some additional items were also added. For that also you approached him. For that, it is but not covered by Exhibit A1. It's beyond Exhibit A1 because it came. The learned trial court has come into an observation. You raised an objection that, see, stop payment because you have not completed the work. You have not completed the work, so you are not entitled to the full payment. That was your case, so you issued a direction to your banker to stop payment. Now, the learned trial court, after going through the material evidences coming on record, has said that the initial agreement for work, whatever is there, that was completed. So the liability of those two checks were established. You could not disprove that. Now you tell me what it is.
My case is that
That is not that
Lordship,
was
this was not raised before both the courts below. No, Lordship, no, my submission. That recently this under order 138B, section B, say check. That means what the check amount is, this say check is dishonored, demand notice has to be made according to that rule. Nothing more, nothing less.
he has not made anything beyond that. He has
No,
just
he has made, let us come to the,
let us see.
let us come to the, at page 3 of the demand notice.
Hmm.
Page 3 at para 3.
Hmm.
By this notice, I hereby call upon to immediately pay an aforesaid outstanding amount rupees 81,91,074. This is what this 81 lakhs, 91,000. 91,000 is not the amount. It is 81,000. This is that. That 9,000. This is the 9,290 rupees extra. This is not the check amount.
Oh, he has only asked that check amount plus this 929.
He cannot. He cannot. This is the.
Okay,
this rule-
fine. You
this
show me.
ruling-
Show me that it cannot be.
This ruling, two rulings.
Please.
I have
please
given
show-
already copy.
Wait, put delay. Oh, yes.
वो भी तो follow है. Safe. That's it.
Yes. Let us see the facts.
Effects also it says. Exactly the both the rulings. Eight, nine, Eight and nine, 8 to 9, it clearly says.
Okay, then the second one is, I
Second
think
one-
this is enough, 2025 latest one. Beer Gawai. And
Lordship,
now let us go back to the,
there are 13 judgment referred on this. 13 judgment has been referred on this.
okay, fine. Now let us go back to the exhibit 3.
Exhibit 6. One notice. It is clearly stated that 9,200 is 90 rupees a separable one. But it was demanded by single demand notice. That extra amount which even if we take it that we agreed to give it 10,000 rupees more, even then, demand notice has to be made only as against that additional check. Nothing more, nothing less.
Now let us just see whether it is severable. If it is not
That
severable,
this judgment of 2002, it is, the same point is again raised. What is severable?
ah, yes. Anything more?
This point was, I must submit that these 2 points were not, because we didn't, at that time, we were not there or we didn't know that particular.
Hmm.
So my submission is a law point.
Hmm.
So this revisional court has power to interfere with these findings given by courts, trial court as well as first appellate court. So by submission before this court, this revision petition kindly may be allowed. Taking of the judgments of both the courts below.
Refers to 2025.
Right? Which again refers 13 judgments of the Honorable Apex Court. All are Honorable Apex Court judgments. Admit demand notice is not a demand notice as per law.
It's one of the ingredients and that has to comply with the demand. It has to be corresponding to the check amount. Yes. Anything more? Only this point?
As regards to that, whether that person, complainant was authorized to do it, because in cross, he said he did not file any letter that he was empowered to file a complaint case.
But you did not pursue that in before the learned trial court. That issue,
Only cross-examine
one, and you did not pursue that matter.
was one
That-
of the ground in appeal, all right. But this point alone is sufficient for this revision to be interfered.
Yes. Mr. Dalda. Never raised.
After they preferred it, then it was reduced. They have already got.
Mr. Talda, before you issued the notice, there was a communication issued to him. Annexed it. So that communication specifically mentions the check amount. Now, the only thing this court is to look into is in pursuance to this 2025 Supreme Court judgment as to whether the mention of an amount excess and the excess is 9,000. Whether that is fatal. The Supreme Court said that anything mentioned beyond is fatal. But the Supreme Court in para 8 has also said from the above reiterative pronouncements and the principles, the position of law that emerges is that notice demanding the payment of amount covered by dishonored check is one of the main ingredients of the offense under so-and-so. In the event of the main ingredient not being satisfied on account of discrepancy in the amount of check and the one mentioned in the notice, all proceedings under section 138 of the NI Act would fall flat as bad in law. The notice is issued under proviso B to section so-and-so, must mention the same amount for which the check was issued. It is mandatory that this in the statutory notice has to be the very amount that the demand in the very amount in the check. After mentioning the exact check amount, the sender of the check may claim in the notice amounts such as legal charges, notice charges, interest, and such other additional amounts, provided the check amount is specified to be demanded for payment. That mention and the separate demand was also there. 9,000. Yes, Mr. Bhagwati. There is, in the case before the learned Supreme Court, Honorable Supreme Court, 1 crore was the check amount.
Second case, let us see.
No, I'll
Yes.
come to that. 1 crore was the amount,
Yes,
and
sir.
in the check, finally, they, without any explanation, they claimed 2 crores.
Yes.
So the Supreme Court said nothing doing. But here it is not the case.
No,
There is
No,
step by step.
no, in that case, let us come to the para 1. Para 1, that is para 1 of the notice.
Hmm.
In the para 1, something has been stated. It is residual amount of 18,81,784 with an additional amount of rupees 9,290. With this, it is not a check amount.
No, he said
All
that
right,
it
but-
is clear there.
No, Lordship, it
And
come with
adding
para-
these two amounts, we cannot be hyper technical here.
No,
Your
it-
liability once having been established.
no, Lordship, that point is also, the
Where?
2000
Where?
judgment has been raised. 2000, that point is also.
Okay, let me see that.
2008.
Which paragraph?
2000 judgment passed by this Committee of the SN Fukan sir. Para again 8. This same was stated here. This is the thing.
This 8 has been reflected, again
Yes.
reiterated.
Reiterated. This is the point. Because
And see, the beauty here is it says that the notice has to be read as a whole.
whole.
So if we read it as a whole, the demand
No.
is there.
No.
You understood the demand.
No.
Now
let-
tell me, Mr. Bhagwati, when you replied to this, did you take this plea?
Not record. This is because there are 138B is a law point. It is a law point. And that law point has been decided by the Honorable Apex. Court.
If, however, in the notice an omnibus demand is made without specifying what was due under the dishonest check.
No, Lordship. Para 3, let us come to the demand notice. By
Of-
this notice, I hereby.
Of the
Demand
present
notice,
case,
Demand notice,
24/9.
24/9. By this notice, I hereby call upon to immediately pay aforesaid outstanding amount of rupees 81,91,000. This is the demand. This is the demand.
That 9,000.
This is the demand.
Then that's
That,
the demand.
no, it cannot be. Yet, because by,
Your explanation was
no,
there,
no, all right. Explanation, why explanation?
No, he does not say, Mr. Bhagwati, that's what my difference is here. You read 3 again, once more.
See, By this notice, I call upon to pay the aforesaid outstanding amount of
Oh,
rupees.
no, you have read it wrong. Outstanding balance of.
No, outstanding balance, all right. The balance amount,
Balance is para one.
no. Now, balance para 1, 9,200, 9,000 rupees, what did say? That 9,000 was not reflected in the border checks. This check did not say about that one, because the check amount comes only, total amount, if you edit, it comes 18 lakhs, 81,784.
Okay, 18 lakhs 81,784 plus 9290
That's it.
is 1891,074.
No, it cannot be, because that it is not a said amount. The what is said amount is there, baby.
Bhagwati, the check amount is not being demanded for payment from you. What is demanded is the aforesaid balance, which also includes the check amount.
No,
Never.
no, lordship, no lordship.
Okay,
This
fine.
I strongly disagree with this point.
Okay,
Because
fine.
both the judgment, all the judgment clearly says this point, because that is separable. That has it separated. That has to be, they can demand anything, costs and compensation and the other amount by separate, demanding separately. 80, that has to be done 81,000, 18 lakhs, 81,000 plus.
You are
so and so.
Prasanto Bora.
Yes, Lord.
He's Prasanto.
Extra amount can be demanded
during
by
trial,
other
there
one,
is also some-
by other ones. Otherwise, demand notice has to specify this only check amount. Thereafter, he can by compensation, by other cost, compensation can be separately demanded. No, here it at 24,000, 24% has been already sought for.
That-
Don't you know how it can be? 24,000 has been already sought for by the same demand notice.
Get it out.
Here in this case, if this is to be done, they have to go to civil, not this way, not by this, by this complete case. 24,000, 24% has been already demanded by the demand notice for compensation. That is as a compensation.
That is allowable.
Okay. Anything more? So you're only on that 1891 and not 1881.
Yeah, my case is supported by the all judgments, that is judgment.
I'm on-
No, that is
Compare
different.
finding revision.
So for para one
I'm
here,
before this revisional court.
Extra stone.
I'm before this
Amount was
revisional
checked
court.
amount, that amount has been separately.
The Learned Counsel for the parties at length. Hearing remains inconclusive. Registry to list this matter again tomorrow. I'll pass the order tomorrow. Just go through. 11, 11, 12. Like, hearing on the top of the list.
In this case, my lord. Petitioner, my lord. The comment servant, my lord. What has happened, my lord? Judgment has been delivered. The appellant here, my lord. Petitioner here, my lord. Whereby, my lord, he was, my lord, for the period under 447 and 325, my lord. Period, my lord, sentences, my lord. my lord, for 325 and 1 month for 447, my lord. Thereafter, my lord, in an appeal. What has happened?
Incident is of 2010.
Yes, incident is of 28/11/2010, my lord.
Yes, madam. Hmm. Everything said and done.
And
Concurrent finding, conviction, no doubt. We are not sending him to jail. Probation of offenders. Disposed of.
my lord, obliged, my lord.
You are for, madam, you are for? State your name?
FIR, my lord, he was convicted. Obliged, my lord.
Record was misplaced. We gave you time. So
Yes, my
today
lord, it is
nothing.
there, my lord, but we try to find.
Let the matter be
My
called
lord.
up. Hmm?
The location, Lordship. I
Huh?
tried to communicate, but I could not.
Okay, no need. You are appearing for the appellant. For the petitioner. What happened?
Lordship, what was happened, Lordship, after passing the interim order, Lordship, they are totally, Lordship, not communicating with me, Lordship.
Okay,
till
fine.
now, even Lordship. Whether they are alive or not, that was also a question, because at the time of filing,
We are not concerned with that.
550 years.
3 eyewitnesses. 2 sisters, 1 father. The father. All have seen the scuffling. 354 ingredient is built in. Huh? Then there is a independent witness who was passing by who saw this. But and you have not dislodged their. And there were some contradictions, minor. That was beautifully taken care of by the learned trial. 447. Your name? NH?
Or we are.
Or we, learned counsel for the petitioner, Ms. A.N. Begum, learned additional public prosecutor appearing for the state respondents. The present, have your seats. The present revision petition has been instituted, assailing the judgment dated 28/2013 passed by the learned session judge Hailakandi in criminal appeal number 18/2009. Upholding the conviction and sentencing of the petitioner herein by the learned chief judicial magistrate wide judgment dated 14/5/2009 in GR case number 171/2007 under section 354/447/34 IPC. The prosecution story in brief is that what is the name of the prosecutrix? What is the name of the prosecutrix? Dulurani Das had lodged an FIR inter alia, had lodged an complaint, lodged a complaint before the Chief Judicial Magistrate Hailakandi, inter alia, alleging therein that the accused persons named alleging therein that the named accused persons had outraged her modesty. Also, it was further contended in the complaint that this is filed by how many people? That the petitioners herein, along with one Abhinash Das on 18/3/2007 at around 9:30 p.m. had entered into the house of the complainant and by dragging her out of the house by holding her hand, had intended to commit a rape upon her. Also, it was also alleged that the petitioners herein, along with Abhinash Das, had tried to disrobe her. Also, she further stated that on raising alarm, the neighbor people from the neighboring people as well as persons passing by having assembled there, the accused fled away from the scene. Also, the said complaint was forwarded by the court to the police and leading to registration of Hailakandi PS case numbers 73/2007 under section 448, 354, 506/30 IPC. So the police, on completion of investigation, laid a charge sheet against the present petitioners and Abhinash Das under section 448, 354, 506/34 IPC. Also, accordingly, a charge was also framed by the learned trial court with regard to the said applicable sections. Also, subpara, on conclusion of the trial, the learned trial court, wide judgment and order dated 28/2013, was pleased to convict and the petitioners herein along with said Avinash Das under section 354/447/34 IPC and sentenced them and accordingly sentenced. Also, being aggrieved, the petitioners herein along with Avinash Das instituted an appeal assailing the said their said conviction before the court of the learned session judge Hailakandi. Also, the learned session judge Hailakandi, wide judgment dated 28/2013, upon appreciating the evidences coming on record, was pleased to dismiss the said appeal, upholding the conviction of the petitioners herein along with said Avinash Das. subpara being agreed, the appellants, the petitioners have instituted the present proceedings. I've heard the learned counsel for the parties and all the materials available. Full stop. The learned trial court, upon appreciating the evidences coming on record, had drawn the following conclusion. 18, 19, 17. On drawing the set conclusions, the petitioners herein were convicted under section 448/354/34 IPC and were sentenced as following. Para 23. Also, the learned trial court, the appellate court, on an appeal being preferred before it, assailing the conviction of the petitioners, void judgment dated 28/2013, was pleased to draw the following. Page 25, para 15, 16. In 19. With the above, by drawing the set above conclusions, the learned appellate court dismissed the appeal and thereby upheld the conviction of the appellants herein. I have carefully perused the conclusions drawn by the learned trial court as well as the appellate court in the light of the evidences coming on record. Also, the evidences of the prosecutrix as well as of her sister who had deposed as PW3 and that of her father and that of their father who had deposed as PW4 brings to the forefront the offense committed by the petitioners herein along with said Avinash Das. Also, it is seen that the said evidence as brought on record through the deposition of the PW1, PW3 and PW4 were not dislodged by the petitioners herein during their cross-examination. Also, PW2 Sirajuddin Barbhia, who is an independent witness, had during his deposition deposed that on hearing the hue and cry from the house of the prosecutrix, he had rushed there and had seen all the three accused persons, including the petitioners herein, scuffling with the prosecutrix in her veranda, and on the gathering of the neighbors, the petitioners along with Avinash had fled away from the place. It is seen that the cross-examination of the PW2 by the petitioners herein, his version could not be dislodged. Also, in the light of the evidences coming on record, this court is of the considered view that the conclusions drawn by the learned trial court as well as that learned appellate court convicting the herein under section 350 under section 447/354 is not erroneous. Also, no infirmity has been found with regard to the on by the courts in the matter. Also, This court had examined the evidences, although the conclusions of the learned, although there were concurrent findings by the learned trial court and the appellate court in the matter, only to satisfy itself with regard to the conclusions drawn in the courts below. Full stop. Learned trial court as well as appellate court. Yeah. Full stop. Having drawn the above conclusion, this court upholds the conviction of the petitioners herein. Also, having drawn the said conclusions, this court notices that the learned trial court, while proceeding to convict the petitioners, while proceeding to sentence the petitioners herein, had noticed the provision of the provisions of the Provision of Offenders Act 1958. However, the benefits thereunder was declined to be extended to the petitioners herein only by noticing the nature of the offense offense committed by them in the matter. So this court notices that the offense was committed by the petitioners on 18/3/2000 and around 18 years have passed since the commission of the offense in the matter by the petitioners here. Also, this court further notices that the petitioners in the matter have been getting the same for the last around 18 years on the trial court, thereafter before the appellate court, and presently before this court in the present criminal revision petition. Also, accordingly, considering the long lapse of time, the petitioners herein are entitled to be extended benefits under the revision, under the Provision of Offenders Act. First, they said benefit being permissible to be extended by this court while exercising its revisional jurisdiction, this court directs that the petitioners here be not required to undergo the sentence of imprisonment, however, may be extended with the benefit under the provisions of Act of 1958. However, this court has not interfered with the penalty, with the sentencing of fine as imposed by the learned trial court. Disposed of, appear 1 month before the Chief Judicial Magistrate and deposit the fine. Fine also. Yes, Mr. Monto, what are you waiting for? Mr. Bhia, Mr. Roy, what are you all waiting for? 16, that is reaching. And Mr. Monto, yours is in the supply. Take it up at 2. You have your cup of tea. Because we have 2 stalwarts here. For 16, that may take some time.
Maybe. And actually, my lord has in the mean.
Oh, that
Vehicle, my lord.
vehicle was repossessed by the bank. You went before the the trial court. Trial court reversed that position. They went up on appeal revision, whatever it is, and the revisional court said nothing doing. You get back the vehicle. Now what happened? The trial court, and that is under stay, I suppose, here. The damage modification, disposal. Nothing is there. Heard Mr. V. Borua, learned counsel for the petitioner, and also Mr. R. Day, learned counsel appearing for the petitioner respondent. R. Day respondent. What's up? the learned counsel for the parties have submitted that in pursuance to the directions passed by the learned, by the revisional court, by the learned session judge Dibrugarh in criminal revision number 43/2/2013, the vehicle in question was surrendered before the respondent by the petitioner in the year was immediately surrendered before the respondent bank, was immediately handed over to the respondent bank by the petitioner herein. Also, it is the submission of the learned counsel for the petitioner for the respondent bank that the said vehicle was auctioned in the year 2018-17. So, after computing the value received on auction of after deducting the value received from auction of the vehicle in question, the outstanding dues receivable from the petitioner worked out to the tune of rupees 7,50,000 bracketed 7,50,000 approximately. Mr. Day, on instructions, has submitted that the bank has written off the said non-performing asset, and accordingly today, as on date, there is no claim with regard from the petitioner herein. The petitioner also submits that he has also got no claim from the respondent bank. So, in view of the above position, this court is of the considered view that the present criminal revision petition is not required to be considered on its merits and is being closed basing on the submissions of the learned counsel for the parties as noticed herein above. Ms. A. report likhi diba, dutak likhi, N. Begum, learned additional public prosecutor for the state.
Obligation.
Mr. Alam,
Yes.
this is the file. Go through it. Huh? Madam, you also go through. Just go through the statements of, this is item number 15. Go through the statements of PW 1, 2, 3, 4, and there is something with regard to the offense. The wife's statement is that when she was sleeping in the house, the boy came in, she saw his face in the light, and then he ran away. So she immediately went to her husband, who was around 50 meters away, informed him, and they came with some people, and this was seen. The brother of this is corroborated by the husband also. The brother says he heard the sound, he came, and he saw the boy running out. Nothing with regard to his sister-in-law. You get my point? Thereafter, the boy, people caught him, brought him, she identified. A gap is there. PW 5. But what happened to the husband? Then the wife, because the wife also ran out. Nothing. It's not, there is nothing on record to show what he saw with regard to these two people. You get my point? PW 3 was held to be bad. He was not considered. His evidence was not considered. Oh, this is, that is Pinku Biswas. This is Aman Rawari. Huh? You just go through the statements once more. Because I find that there is a constituency. If you say, if you can satisfy this court, that is a very minor thing, then to things fall in place, his conviction has to be upheld. Because it's very clear that she raised alarm, accused left, she immediately went. Then there is a PW 3, the PW 4, Rupala Boru. Here, she does not say about the lady going the victim going out of the house again to inform her husband, who was around 50 meters. There was a theater going on. Go through it. See the evidences also.
Case, my lord. The fact is that
Hmm.
against equital, my lord. The case of the company had given 9,81,500 on 1st of September, April 2007, my lord.
Hmm.
In respect of advance towards the flat, my lord, and in case if he doesn't pay, my lord,
So total claim is around, a debt is 9,81,500.
500.
Check was for an amount of
3 lakhs, 3
Uh,
lakhs and 3,45,000.
45,000. So
Rest small amount on the cash.
cash. So check is for 6,45,000. So you're
Check is 9 lakh
9,81,000.
I'll come to that.
No, just
3 checks.
what I got just to
Check
take it off. 3
60
checks.
68 and 69.
So total amount 9 lakh something. The evidence on record is that 6 lakhs odd was paid back. But your claim in the notice is 9 lakhs. That is the discrepancy.
No,
Huh?
no. Claim is 6 lakhs.
6 lakhs.
30,000, 60,000. Next.
Hmm.
He said, you have not returned my check. Whatever is entitled to, we'll pay within that time.
Hmm.
That is our reply.
Hmm.
Now, in the legal notice, my lord will kindly appreciate the legal notice that it is talks about 9 lakh.
So where is that legal notice? It's on record.
But your lordship has to see all the facts, my lord.
Yeah, I'm here to, but
Legal
let me
notice,
get
lord.
this thing out of my head.
Yes, legal notice.
That is, business notice activity.
Exhibit 8 and 9.
By mistake, that 30,000 was shown, my lord, in the legal notice, first legal notice.
40,
But-
45.
And subsequently it was corrected, my lord, and it
Reported
total
to me
amount of-
that you had issued a check of rupees 60,000 only being so and so. Check was deposited with the bank for the client and the amount of sufficient. Therefore, then again you issued 2 checks in the name of so and so, client number 3
is 30.
for 30,000 having so.
Parvinder's.
Hmm. But the said check was returned unpaid, so and so, but my client approached you and requested you several times to clear. You are liable to be prosecuted, imprisonment, so and so. This is the first one. Now let us see the second one.
Second was only corrected to 3 lakh rupees, my lord, para 3.
Mm,
Para 3.
each having check number so and so, so and so. But you issued check number so and so, so.
Admitted fact that, my lord, 3 checks has been issued by.
But where is the
96%.
demand amount?
Not on the.
Anyhow, my lord.
What is your reply to this?
Yes, page 48, my lord. Now,
You are Jotindra Bharali.
now para 2 may be seen, my lord.
48.
That-
So and so, so and so. Client is not, and then
So what is the balance now due from you, Mr. Anbhuya?
Balance is zero.
Zero.
And
Okay.
even after
After filing of the complaint.
yes, yes.
Then I've seen it.
Cross-examination part here.
Okay, we'll hear Mr. Roy. Yes, Mr. Roy.
Lordship may see Exhibit 1 and Exhibit 2. Exhibit 1, Lordship, page 32, my lord. The paper book. That is amount to 3 lakh rupees, my lord. Check number is 628467, my lord. Then the second check, my lord. This first check is dated 18/5/2009. Second check is 25/2009, amount of rupees 3 lakh. And check number is 628468, my lord.
Hmm.
And the third check is at Exhibit 14, my lord, which is at page, my lord, 51. That is 3,45,000, my lord.
For
check-
9,45,000.
Yes, and dated is 22/5/2009, and check number is 628469. So 67, 68, and 69, my lord. 3 checks. My learned friend's client has given to the complainant, my lord. Now, my lord, there was
Checks all given by J. Bharali.
J. Bharali.
Okay.
To my client, my lord, and other 2 is not there, my lord, but
You are NH Ali.
N. Hussain, my lord. NH Ali.
NH Ali.
Now, Exhibit 7 is in dispute, my lord, but Exhibit 7 may be seen, my lord, which is at page 38. This is in plain paper, my lord. And this shows that total amount is due is 9,81,500. This is signed by J. Bharali on 22.
This was sent for examination also.
The report has come that is the same handwriting, but my learned friend has very effectively cross-examined the forensic.
And it was demolished.
But prima facie, my lord, is on 22/5 and he signed it, my lord. And lordship may see the amount also tally, my lord, 9,81,500. He had 22/5/2009, 6,65,000 he has paid, and 35,000, 1 lakh, and 2,10,000 rupees check he has given, my lord. Now I come to the judgment, my lord.
Now, let us see the evidence.
Evidence, yes.
Hmm.
Then, my lord, this is the the complaint is at, my lord. Yes. Sir,
Complaint is there in your, I
yes,
think.
yes, it's there. This is an appeal memo, my lord. Page 17, my lord. First is the cost title, my lord. Now, page 18, my lord. That the above named accused is the
No, we got it. That is the description.
then para 2, my lord. That the complainant present the
Got it.
state 2 checks. State
And the 2 copies of the demand notice. Now tell me why the demand notice was also issued in the name of 2 other persons.
my lord, actually, fact. Yes, pay to the other 2% plus my client. A lawyer who has issued the notice. He
So that notice itself is defective. Cannot be held to be a notice under 138 proviso.
has been she has combined it and it is written in the notice, my lord. Lordship may see for a moment, my lord. In the notice, para 4, my lord, page page 44 may be seen, my lord. That you issued check number 50,000.
44 of paper book.
Paper book, my lord.
Hmm.
So she has combined
I think this whole notice, the second one,
second one, page 44. That you issued a check of 50,000 to
to Parvinder Singh.
Pradeep Kumar Sharma, client number 2, bearing number so and so. Para bench, but the check was bounced.
You're reading 40?
4.
Okay. But where is Ali here? Hussein Ali.
Ali is para 3, my lord.
Two checks.
Yes.
Each having check number,
Yes.
check number.
Check number.
What about 3,45,000? That check,
That check, my lord,
there was no notice.
notice because by that time the 3
One
lakh
ingredient is missing.
no, 3 lakh has
There
been
was
paid.
another case been filed. Is technical for that.
Against 345.
No, I don't know.
Yes, yes.
Yes,
Yes, these are bundles.
but here is the case is 6 lakhs because he has in the meantime paid 3 lakhs. So
Show me that the demand 6 lakhs.
6 lakh is in this
Not
notice
there.
only, my lord. That,
Where have you
that is para
demanded?
3, my lord. That again, you issued 2 checks in the name of Noor Hussain Ali, client number 3.
This checks, Mr. Every check here
Both
will
the
have a
same
different, I can understand you're clubbing up 2 checks,
checks.
62844 and 628,468.
Just to check.
26. But what about this Pradeep Kumar, Pravinder? They are not parties in the complaint.
No, no, they are not
They
party.
ought to have been parties in the complaint if there is a demand made by them. How can you have this?
I have only my case I have projected, my lord. I have not projected the case of Parvinder Singh or Pradeep Kumar Sharma, my lord. I'm not fighting for on their behalf, my lord, but notice was admittedly notice has been issued.
This
all the-
notice is defective. Okay, then what happened?
Then the reply at page 45, lordship already seen it, my lord. Now, what is the reply lordship may see?
Part payment has been made
Yes. Part payment has been already
Ah,
made with
and your
the
client is not, that is his denial.
under denial.
Now-
the
now-
payment-
Paragraph. Phone. Phone, and that becomes.
Correct, madam, because he said that he was a builder, my lord, and also a friend of the complainant, my lord. So he said that he will give a flat, otherwise he'll return back the money, my lord, if he doesn't pay the give the flat. So with 5% interest, my lord. That was the case, fact, my lord. Now, reply is very clear, my lord, and he is he is only the complainant, my lord. Para 2 of the reply, my lord, that lordship may say 48. That further with regard to check number 67 and check number 68, it is for your information that my client has already made part payment of the aforesaid checks. Now, what is the part payment? Nothing has been reflected here, my lord. And as such, my client under the belief that on payment of balance amount, your client will return the aforesaid check, which is but to the utter shock and disbelief of
So,
my
well, let us not go into such this thing. Let's go to your evidence.
the evidence, my lord, lordship may say, I'm seeing the appeal, my lord. The cross may be seen, my lord. Page 37, my lord.
Paper book or-
It's not in paper book, my lord, but
it.
paper book is said that, but lordship cannot read it. Lordship may see from the appeal memo, my lord.
Page 37.
37, my lord. The fact, I'm reading it. The fact that on 27/5/2009, I received an amount of rupees 3 lakhs and I did not issue any money receipt to that effect. I have paid different amount of money to the accused at different time. I do not remember the date the accused. The receipt of various amounts. I have not produced any money receipt in the court as much as the same were returned to the accused. On 11/6/2009 and 12/6 legal notices issued. Fact that legal notice that amount of check mentioned rupees 30,000 each bearing check. Notice dated 12/6 aforesaid check amount like each. It fact that and both the notices 11/6 that the accused has taken from me. It is fact that I have a legal notice demanded for repayment of the accused. Legal notice I have not mentioned about like 81,500. It is fact that accused did. Fact that in my complaint petition and in the legal notice, I have not mentioned that accused at the time taking money from me, but the same has been mentioned in my evidence on affidavit. Fact that in my legal note, I have mentioned only about 2 checks as being number 627 and 68. It fact that in my complaint petition, I have mentioned about 3 checks being numbers 67, 68 and 69. In the legal notice, I have stated that the accused had taken loan. My complaint petition and evidence, I have stated that money is for providing me with the flat. It is a fact that accused through lawyer replied in the writing to the legal notice. It is a fact that accused as stated in the reply that I am not entitled to get from him rupees 60,000 as stated in the notice. As stated in the notice. Also true that in the reply accused stated that even after receipt of the part payment of the check for 67 and 68, I have not returned the checks. It is a fact that it was written that the balance amount would be made within 15 days. It is a fact that Exhibit A was issued by me to the accused. A2 is my signature. Exhibit A issued on 22/5/2009. In my Exhibit A, I have written that received back the lend amount of rupees 65,000 in lieu of check number 67 dated 18/5/2009 out of rupees 3 lakhs. It is a fact that accused deposited to rupees 25,000 in my account on 25/5/2009. It is a fact that I received an amount of 2,10,000 on 27/5/2009 by way of check, an amount of 50,000 after filing of this case. Appearing in Exhibit 7, accused number 7A is the signature of the accused. 7B of the name of the accused written me. It is not a fact that 7A is not the accused. Exhibit A also I have stated that the part payment of rupees 60,000 was received by me of lending amount. I do not have any license for lending money. The fact that I have not made my legal notice that accused had make payment in addition to tax. I have not produced the original of check number 469. It is not a fact that accused took from me amount of rupees 6 lakhs and the same I received. It is not like 50,050 9,81,500 to the accused. Not a fact that I am blackmailing the accused. Now the question is this, my lord. He has paid 3 lakhs. That is, your lordship may be seen, but there is no explanation to the rest.
Okay, forget it. Forget it. 2 checks amalgamated.
Yes.
So the total amount is 6 lakhs.
6 lakhs.
So let us go by that. Let
No.
us go by that.
Lordship also has to.
The third check is nowhere there.
Lordship has also to be seen about that Exhibit 7, my lord. 7. That is in the paper book, my lord.
That signature of his.
Yes, yes.
Forget that. We'll come to that. We'll come to that also. We'll come to that also, Mr. Roy. We'll come to that.
Check has been returned back after payment of rupees.
Fine. But here, the check involved is 62,487. that is not returned back, that has been utilized by you, and that is forms the part of the complaint. Now, you come to page 39, the amounts there,
That is in the paper book.
paper book. No, not paper book, your,
The bill.
the type portion of the deposition.
39, my lord.
So the liability claimed is 6 lakhs.
Yes, liability claim 6 lakhs.
Now, if you go by this page 39, first paragraph, forget that 50,000 which he made after the filing of the case. 3 lakhs is already admitted to have been refunded to you.
What, my lord? That is what?
No, no.
No,
See,
your
the claim
worship-
cannot be 6 lakhs. 3 lakhs is already given back to you. Now, what is the date of the legal?
Only
No.
A.
Mr.
Lordship
Chaudhary,
see-
Mr. Roy, this court is,
Submit that, my lord.
this court is slow in understanding, so let it understand first. Now come to the legal notice. What is the date of the legal notice?
6/12/2009.
So your first amount of 65,000 was paid on 18/5. 25,000 was paid on 25/5. And 2,10,000 was paid on 27/5/2009.
Right.
Now you come to your legal notice. Your legal notice is, first one is 11/6.
My lord.
Huh? And the second one is
12/6.
12/6. Now this legal notice, this statement, total contradiction. There is no liability. Or at least forget 6 lakhs, 3 lakhs liability is not there.
3 lakh liability is not there.
Not there.
Very good. But that is not a big, but we have taken a plea, my
So
lord.
this notice seems to be somewhere just to make a wrongful gain for yourself.
No. This.
We'll have it at 2. Mr. Bhuya, as an officer of this court, is there any error in the understanding of this court with regard to the extent of the evidence? Just as an officer, not as a. At 2. I think you'll have to satisfy me that beyond this thing, there was a 6 lakhs demand.
Oh, no,
You should.
that was the art of examination because he had paid 3 lakhs and he has taken the check that 6 times. 3,45,000.
I can understand your client's position when Mr. Bhuya is appearing in the other side.
I know.
But thing is, I can't
No,
take
Lordship,
notice of that.
But
I'll have to
Lordship
see
has
what
to-
is there in evidence.
Lordship has to see Exhibit 7, burden of proof. and
Exhibit
everything.
7 has been dealt with by the learned trial court, and I'm sure that conclusion will not call for a recall. You take me, show me from your evidence that yes, this is a due,
And it is the.
at least 6
it is
lakhs.
Also the burden of the accused to show that when the payment is made.
No,
there's
once
no
you will have to, as far as I've understood, you will have to prove the liability.
liability.
Once the liability is there, the presumption would be that the check
Yes.
was issued
Yes,
in absence of, for mitigating that liability.
right.
Then the onus comes to him. He will have to show that this is not a liability, or however he shows. But you have not crossed the threshold of the first point.
I'll come to that.
That much only you show me. Then we'll have Mr. Yes, Mr. Roy.
I'm going to the legal notice again, my lord. Other person, they have filed their cases, my lord. I'm not concerned to that person. I'm only concerned to Hussain Ali, my lord. Now, your lordship said, where is the demand? But lordship may see the page 43, my lord.
Paper
my lord,
book.
Paper book. Against my client, my lord. Para 3 stated that both the checks were deposited with the bank and the para 3, my lord. That again, they issued the 2 checks in the name of our Noor Hussain Ali, client number 3 lakh,
Hmm.
each having check number so and so, 5, 2029 respectively drawn on State Bank of India, Pandupur. Both the checks were deposited with the State Bank by my client for payment of 2009, but the said checks were returned unpaid on 5/6.
So this is the demand. We got it.
Yes, this is the demand. And then the against that reply is given, my lord, which is at page 40. Both the notice, the reply was given, my lord. Now para 2 may be seen, my lord. That further with regard to check number 67 and 68, it is for your information that my client has already made part payment of the aforesaid checks. And as such, my client was under the belief that on payment of balance amount, your client will return the aforesaid 2 checks. But to the utter shock and disbelief of my client, your client named Noor Hussain Ali has, in spite of receipt of the part payment of the aforesaid 2 checks, has deposited the aforesaid 2 checks in the bank.
Mr. We have got it. But your evidence, your cross that you had taken me now through, therein you will find.
Now, before that, my lord, your lordship may see the exhibit 14, that is page 51, that I paid 3 lakh, my lord. Top, my lord. Return check, my lord. So he has deposited 3 lakhs rupees. I have returned that check, this check, my lord, to him. My case, my case is.
There is no evidence to that effect, Minister. No evidence.
I'll come to that, my lord. The
This
evidence-
check was also bounced.
Yes, this check was also bounced.
Where are the other 2 checks?
Other 2 checks is at lordship may see.
Exhibit 1 and Exhibit 2.
Exhibit the page 32 and 33, my lord.
But there is no evidence supporting this, that words return check.
Here is not exhibit 1, exhibit 2 is not written, my lord, because this.
No. But
Amount-
this return check,
Yes,
if you write, if you have said this,
yes.
then where is your evidence to that effect that this check
But
was
I've
never,
exhibited it, my lord.
you exhibited a Xerox copy, secondary
Yes,
evidence.
Yes, because the
Where
check
is
was
that?
returned, my lord.
Because you have, that is why the court said it is not compared with the original.
Yes.
So that is a check.
Very
So where is the further evidence that this check was returned because the money was paid?
That is the exhibit 7, my lord. Exhibit 7.
Mr. Roy, a further query.
Yes, exhibit 7 is.
The exhibit 7, it is the signature which has been examined. Whether the writings are also examined.
I have given, my lordship may take my appeal memo, my lord. Lordship may see para 6, my lord, page 21, my lord.
Appeal memo.
Complaint, my lord.
Para 21 of what?
Appeal memo, my lord, page 6, para 6,
Para 6.
page 21. That actually the accused has not made any single pie against those 2 aforesaid checks. The actual fact is that accused is properly dealer and flat builder. He, being a friend of the complainant, offered a part of flat in metropolitan Guwahati city, for which he asked the complainant rupees 9,81,500 only in advance in a part wise. The accused will give the complainant as a benefit of 5% less of value of selling equal part of the flat, or if the money is to be returned in cash, 5% interest would be provided of the principal amount. So the complainant gave aforesaid amount of money since 1st April 2007 in part wise. But during the current year, the complainant has not seen constructing any flat anywhere in Guwahati. So he asked the accused to return the entire money. He promised to return the entire amount of money in part wise, mentioning date and putting his signature on 22/5/2009 in a white paper. That is the exhibit 7, my lord, in paper book, page 38. Then next, miss, page 22, my lord. The accused has made payment of rupees 65,000 only in cash, rupees 25,000 only deposited in complainant's account, and rupees 2,10,000 he has made payment through check bearing number so and so 76 dated 27/5/2009 and another rupees 45,000 only promised to make cash. So the check was issued by the accused to the complainant having check 69 dated 22/5/2009, quoting the entire amount of money rupees 3,45,000, but the complainant accepted the cash money and the check of rupees 2,10,000 only, and the complainant returned the check 69 dated 22/5/2009 to the accused and gave a money receipt to the accused of rupees 65,000 and only against the check number 67 dated 18/5/2009, which ought to be written against the check number 69 dated 22/5/2009 and return check. And there is no cross examination on this, my lord.
No, where is that check, return check page?
Return check. That is page 51, my lord, paper book.
Now you have given an acknowledgement.
Yes,
That is the next page.
yes, that check number is wrongly mentioned, my lord, 67, it should be 69. my lord.
Say everything now you
But
can say.
I have explained in my complaint, my lord.
Where, but complaint you have explained, but in your cross whether this has come out.
But they have also not cross-examined on this line, my lord.
And this amount, you come to the certificate,
Yes,
this is only 65,000 in lieu of check number 628467
67.
dated 18/5/2009 out of 3 lakhs. And Mr. Roy,
Yes,
there is another catch here. You see the date of the receipt? Page 52
yes, 22/5/2009.
and the date of the check 68469.
That is a different check, my lord, but lordship may.
No, this check,
Exhibit 14 may be seen,
exhibit 14 only I am saying,
Yes.
return check,
22/5/2009.
same day.
Same day.
Why did you give a check on the same day? Where is that that portion that this check was given? However, the money being paid, this was written.
This is, I've explained it, my lord, at para, my lord.
Hmm.
Page 22, my lord.
Hmm.
The accused has made payment. Lordship got it.
Huh.
In my appeal memo, my lord.
Yes.
The accused has made payment of rupees 65,000 only in cash. Rupees 25,000 only deposited in the complainant's account.
Hmm.
And rupees 2,10,000 has been made payment through check bearing number so and so. And amount of rupees 45,000
Hmm.
to be paid subsequently, my lord. But this, if we calculate, my lord, it is 3 lakh, my lord.
3 lakhs.
65,000 plus 25 plus 2,10,000.
3 lakhs.
3 lakhs.
Okay.
So he has returned that 3 lakhs, my
So
lord.
a check was issued by the accused to the complainant having check number so and so, that is exhibit 14.
Yes,
Huh?
exhibit 14.
Exhibit 14. But the complainant accept the cash money and the check
Yes.
and the check
On
of
the
rupees
promise
so
to
and
make
so.
cash, so a check was
And the
issued
complaint
with-
returned check number so and so to then give money receipt to the accused of rupees 65,000
Yes,
only against check number so and so. So this is correct. This was against check number 628467, not
next 3 lines, my lord.
which ought to have been written against check number so and so. This cannot be because this is not a part of the debt now.
At that time, my lord, for check number 69, we have.
Your total debt is 6 lakhs.
8 lakh, 9 lakh, 81,500.
Okay, let us see. 9,81,500. Now you get 2 checks, 3 lakhs each.
3 checks.
No, 2 checks. First,
The case is for 2 checks, but we have 3 checks, my lord.
I got it. So that would be 500. So you have a balance of 3,81,500. 9,81,000 is your total liability.
Total
His
liability.
liability, Mr.
Yes.
Anand's liability.
Yes,
He has given you 2 checks
Three checks, my lord.
No, no, two checks first.
First two checks,
6 lakhs.
67, 68 and 69.
3-6.
Three checks.
I know. What is the value of 67?
Yes, 67 is 3 lakhs,
3 lakhs. What is the value of 68?
3 lakhs.
3 lakhs. So these two checks were given to you on which dates?
Earlier paid, my lord.
Hmm.
And 69, my lord.
No, no, no. 69 will come. Where is
Yes.
67 and 68? Let us clear that.
My lord,
Exhibit 1 and 2.
exhibit 1 and 2.
32, 33.
32, 33, my lord.
Let us see the dates.
Yes. 32, 33, my lord. That is check number 67, 3 lakh.
Uh,
Check number 68,
uh,
3 lakh.
This is dated
Date is
18/5,
18/5/2009, my lord.
18/5/2009, and the second one is
25/2009.
25/2009.
And third one is, my lord.
We'll come to third one. Now, on receipt of these two checks, your balance liability comes down to 3,81,500. Out of 9 lakhs, 9,18,000, you have not been paid. You have not been paid the amount, but the two checks were with you. So he has discharged his liability by paying you two checks.
Yes.
Dishonor part, we
Yes.
are coming.
Yes.
Now the balance is 3,81,500. So he issues to you 3,45,000 Annexure 14. Exhibit 14. No. Then what?
My lord, lordship may see 3 checks as given, the date 18/5/2009,
25?
25/2009
Ah,
and 22/5/2009.
okay.
3 different dates, my lord.
Ah. And
So he paid 3 lakhs, my lord.
Ah.
As we have, lordship has seen it, my lord, 65,000 plus 25,000 plus 2,10,000.
Hmm.
So we have returned this check, my lord, exhibit 14. So
Hmm.
my balance due is 6 lakhs.
okay. No, it's not
But
6 lakhs.
in-
It is 6,81,500.
Whatever it was,
Ah.
this is there. But in the, when we return the check, my lord,
Ah.
the check number is written wrong, my lord. Because on 22/5/2009.
Okay, let us see the evidence now on this.
Yes. Yes. 37, my lord, page number, paper book. Oh, no, sorry, in the appeal memo, my lord.
37. Okay.
It is a fact that on 27/5/2009, I received an amount of rupees 3 lakhs and I did not issue any money receipt. To that effect, I have paid different amount of money to the accused at different point of time, but I do not remember the dates on which I paid to the accused. Accused issued money receipts to me acknowledging the receipt of various amounts. I have not produced any money receipt in court in as much as same were returned to the accused. But that bank statement we have enclosed, my lord, that check has been, money has been paid. On 11/6/2009 and 12/6/2009, 2 legal notices issued to the accused. It is a fact that legal notice dated 11/6/2009, the amount of check mentioned is rupees 30,000 each, bearing check 67 and 68. Legal notice dated 12/6/2009, mentioning the aforesaid check amount of rupees 3 lakh each. It is a fact that in both notices 11/6/2009 and 12/6/2009, it is mentioned that the accused had taken loan from me. It is a fact that I have, through the legal notices, demanded for repayment of loan of rupees 6 lakhs by the accused. It is a fact that in the legal notice, I have not mentioned about the outstanding balance of rupees 9,81,500. It is not a fact that accused did not issue any money receipt. It is a fact that in my complaint petition and in the legal notices, I have not mentioned that accused issued money receipt at the time taking money from me, but the same has been mentioned in my evidence on affidavit. It is a fact that in my legal notice, I have mentioned only about 2 checks as being number 6.7 and 6.8. It is a fact that in my complaint petition, I have mentioned about 3 checks being numbered 67, 68, and 69. In the legal notice, I have stated that the accused had taken loan, and in my complaint petition and in my evidence, I have stated money has taken for providing me with a flat. It is a fact that accused through his lawyer replied in the writing to the legal notice. It is a fact that accused stated in the reply that I am not entitled to get from him rupees 60,000 as stated in the legal notice dated 11/6/2009 and rupees 6 lakhs stated in the notice dated 12/6/2009. It is also true that in the reply accused stated that even after receipt of the part payment of a check 67 and 68, I have not returned the checks. It is a fact that in the reply it was written that the balance amount would be made within 15 days. It is a fact that Exhibit A was issued to me and Exhibit A 1-2 is my signature. Exhibit A was issued on 22/5/2009. In my Exhibit A, I have written that received back the lend amount of rupees 65,000 in lieu of check number 67 dated 18/5/2009 out of rupees 3 lakhs. It is a fact that accused deposited rupees 25,000 in my account on 25/5/2009. It is a fact that I received an amount of rupees 2,10,000 on 27/5/2009 by way of check. An amount of rupees 50,050 was
We'll
deposited.
leave that.
Yes, sir.
Mm.
Signature appearing in Exhibit 7, accused number 7A is the signature of the accused, is the name of the accused written me. It is not a fact that Exhibit 7A is not the signature of the accused. In Exhibit A also, I have stated that the part payment of rupees 65,000 was received by me of the lending amount. I do not have any license for lending money. It is a fact that I have not mentioned in my legal notice that accused had to make payment in addition to rupees 6 lakhs. I have not produced the original of check number 69. It is not a fact that accused took from me an amount of rupees 6 lakhs and the same was returned to me with receipt. It is not a fact that I received rupees 6,50,050 from the accused. It is not a fact that I have not paid an amount of rupees 9,81,500 to the accused. Fact that I am blackmailing the accused.
So you have not brought out anything here with regard to the return of that check. 3,45,000.
That is the cross examination. This is the cross examination.
Ah, I got it.
So
In the cross,
in the cross, whatever he has crossed, that is, he has not touched that part, my lord.
no.
But because he has to cross examine and.
Now,
his
without
cross-examine-
mentioning the third check in the legal notice, can you bring it on record?
That because the 3 lakhs has been paid against that check, that's why we have written that. check.
That aspect, show me where you are saying, where is your evidence on affidavit? No, it's there at page 32.
Thirty-two is the, yes. Nursen so-and-so, that I am complaining in this above noted case, filed against accused Jatendra Bharali, that I paid rupees 9,81,500.
Okay, you have said this here.
Then para.
I returned him back the check number so-and-so for 3,45,000.
Hmm.
Only as on that day, that is so-and-so,
Para
I
five-
carried the
Then
aforesaid
para
check
5 may be seen, my lord.
because he promised to pay the clearance so-and-so. When you said that you returned this check on 27/5,
Yes.
whereas you issued the certificate on 22/5 and the same check was issued on 22/5, that explanation I am not getting anywhere. He made a part payment, Exhibit A,
Yeah,
which you exhibited,
Exhibit,
65,000
Yes.
in lieu of check number so-and-so.
yes.
Now, if that be so, what was the point in issuing a fresh check on 22/5 itself? On which date he made a part payment to you?
Check was paid earlier on that day, on 22/5/2009, because when the check was returned, the lordship may compare page 38 and page 52 for a moment, my lord. Lordship may see page 52 and paperwork, my lord, and page 38. So here is also in his own handwriting.
No, we'll come to that. We'll come, his
I'm
handwriting
saying-
is proved only to the extent of his signature there.
Hmm.
The writing has not been proved.
Prima facie, my lord,
No, prima facie, how can we, when once that is not proved? The evidence is with regard to the, and that is gone now. After the cross.
Lordship may see this thing and
Now, just tell me, what was the point in taking a check on the date when he made a part payment? What was the idea behind that?
Lordship, the check was given earlier. Lordship may see
No, it was given on 22.
22.
And your that part payment exhibit was also on 22. Annexure A.
Date he has put, my lord, that the date is given by him
Who?
and
Where?
in the check, my lord, that is issued earlier, 22/5, Lordship may see
Okay, he gave you a check of 22/5 earlier.
earlier.
Accepted. Where is that in your evidence? Where do I get it?
Yes. I'll come to that.
45,000 never been present.
No, he did not present. He returned it to you.
No, because he has paid that amount, my lord. Why should I produce the check, my lord?
No, he did not.
Yes.
He's not produced the original also.
I'm reading it para 2, my lord, of my evidence on affidavit. Para 2, that I
I
paid.
got it. You can come to page 33. But at last, he issued me 3 checks.
Yes.
Continuously. White
fine.
check number
That for
18,
which I issued
20
a demand.
and 25. Only for the balance of rupees so and so. But he promised to pay in cash and return. He took back the entire money receipt. Whatsoever the accused could not show any construction or building within Greater Guwahati. And I accused that construction. So I asked him if he is not able during the have returned my and made payment of rupees 65,000 on 22/5.
On that only I will return the check to him also, my lord.
Okay, let us see. Accused made a payment in cash of rupees 65,000
Where
on 22/5.
Lordship is reading where?
33, page 33
Page
of the
30.
appeal
Yes,
memo.
Yes.
Second paragraph.
Yes. So the accused made a payment of rupees 65,000
Hmm.
only on 22/5/2009 and deposited rupees.
Now let us just hold it for a second there. Come to the certificate.
Yes. Yes.
Now,
This is
this 22/5 is the date you made the payment. On that day,
65,000.
65, on that day, this 22/5 was not handed over to you. 648469, you say he has returned it post dated. When was it actually handed over to you? 469. Exhibit 14 was handed over to you.
Exhibit 14 was. One minute, madam. I'll come.
If you can show that you had this check
Yes.
prior to issuance of that, then you returned, fine. There is a plausible answer.
I'm reading it that's as per your lordship, 33, page 33, my lord.
Hmm.
So the accused made a payment of in cash 65,000 on 22/5/2009 and deposited rupees 25,000 only in my account on 25/5/2009 and paid through another check of rupees 2,10,000 by check number 76 dated 27/5/2009 on 27/5/2009. That is in total paid back rupees 3 lakhs only to me, and for which the same day, that is on 27/5/2009, I return him back the check number so and so dated 22/5/2009 for rupees 3,45,000. So that I as on 3,45,000 only as on date on that is on 27/5/2009. I carried the aforesaid check rupees 3,45,000 only because he promised to pay to clear the amount of his 3,45,000 only, but unfortunately he could not do so. He cleared up to rupees 3 lakhs only, and for the balance of rupees 6,81,500 only two checks, number 67 dated 18/5/2009 and check number 68 dated 25/2009 for rupees 3 lakhs. Only
Look.
cash remain in the hand of the for taking payment, and he promised to make the payment of rupees 81,500.
Mr.
Lordship, may see one more line, my lord. Page 32, the last line, my lord. The accused, last line. Page 32, my lord.
Hmm.
The accused took the entire money on a partwise basis, given money receipt of the amount, but at last he issued me 3 checks continuously, while check 67 dated 18/5/2009 for rupees 3 lakhs, check number 68 dated 25/2009 rupees 3 lakhs only, and check number 69 dated 22/5/2009 for rupees 3,45,000.
So, Mr. Roy, it is not a part payment against 3,45,000. It's not a part payment against 3,45,000 as you want to project. You had written the check as per your evidence in affidavit, page 34,
Yes.
because on that day you were carrying only that check. So you returned it to him. So the certificate that is there, it is a part payment of that check only.
That's why that we said by mistaken it was.
No, it
60 to
cannot be
69.
a mistake. It cannot be a mistake because on 22/5/2009, when you issued that check, right, you had no intention of returning the Exhibit 14. Exhibit 14 was returned only on 27/5/2009. Because on that day you were carrying that check only.
Because on 27/5/2009 he cleared 3 lakh rupees.
So you read
Yes,
that
you are-
page 34. On that day, that is on 27/5/2009, I carried the aforesaid check of rupees 3,45,000 only because he promised to clear the balance amount of rupees 3,45,000.
But at
Only.
last he issued so and so and and on rupees so and so for rupees 3,45,000 only, and for the balance of rupees 36,500 only, no check or any receipt was issued. But he promised to pay the cash, and in return he took back the entire money received whatsoever.
Now tell me one more thing. This complaint is for 3 checks or 2 checks?
2 checks.
So that 2 checks, Exhibit 1 and 2. So Exhibit 1 and 2, the evidence on record clearly shows that a part payment was made with regard to Exhibit 1 or Exhibit 2 as it may be. It may be Exhibit 1, 18/5, Exhibit 1. So if that be so, how can your demand, and where is your legal notice?
Yes.
Come to
Legal
your back to your
notice.
legal notice. We'll go by the second one. It is dated
12/6.
12/6. Now show me from here where you have returned the check. Because the check was returned on 27/5. Now show me.
It's not written.
Then
Not written.
not even a whisper here.
That's correct. We are admitting that part.
Oh,
But we have filed for these 2 checks, not the other check, my lord. Because in the complaint, I have stated elaborately that how this has happened, but the notice.
no, complaint
not-
is a development. We'll have to go through these
Yes,
stages.
very correct, my lord.
Hmm.
But in the legal notice, we have mentioned for the check amount which is dishonored.
Yes.
And we will explain it, my lord. These 2 checks were dishonored because insufficiency of fund, my lord.
In your complaint, you have
I've explained it also, my lord.
explained it. But the thing is, where is that explanation or when you make a demand, you will have to make a demand on the basis of the materials available on record. Okay, now let us see the conclusions of the learned trial court.
Yes.
Page 20.
Lordship, seeing the judgment, my lord.
Page 28,
Page 20
discussion and results.
27. 28 discussion also. Point number A. On this point, version of complainant is that accused person took 9,81,500 only from the complainant, and in its part payment issued with 1 and 2 checks in favor of the complainant. On this point, from the trend of cross-examination of complainant and answers given by accused in his state defense, the story of defense comes that accused admits issuance of both the checks in favor of complainant, but as security, and took plea that he had repaid the amount to the complainant. Accused did not admit the claim of complainant of rupees 9,81,500 only, and placed story that only rupees 6 lakhs only was taken by him, and he had repaid the amount of rupees 6 lakhs only, and further 50,050 only as interest. So in the light of these factual differences, I have to analyze evidence on record. On this point, complainant gave evidence of affidavit and exhibited checks in question as exhibit 1 and 2. Both these checks are in the name of complainant and bear rupees 3 lakh only in each. Here it is important to note that very existence of exhibit 1 and 2 checks in their present form give presumption in their favor under section 118B and 139 of NI Act that those were so issued in discharge of debt or liability. This is mandatory presumption and court is duty bound to raise it, but at the same time it is rebuttable presumption, but naturally its burden is upon the accused. The subtle position of law in this regard is that to rebut this presumption, accused need not necessarily give evidence from his side. Rather, he may rebut the same taking help of materials on record placed by complainant also. So I have to analyze the evidences on record in the light of the legal position. On this point, I see that in his evidence on different complainant supported evidence on affidavit complainant supported his story as discussed earlier and shown as how liability of accused was for the amount mentioned in the checks. Now I see cross-examination of complainant and find that in his lengthwise cross-examination, he admitted that accused paid him rupees 3 lakhs only, for which he did not issue any money receipt. That rupees 65,000 only was paid by accused while exhibit 8 on 22/5/2009. That accused deposited 25,000 only in the account of the complainant on 25/5/2009. That rupees 2,10,000 only was paid by accused by check on 27/5/2009, and that after filing of the case, accused paid 50,050 only to the complainant. So if I go by these admitted payments, then find that before filing of this case, accused had paid rupees 6 lakhs only to the complainant. Here it is important to note that this admitted.
So this finding that around 6 lakhs has been given, this is from an appreciation of the evidences coming on record. 3 lakhs deposit, another 3 lakhs by way of something, 6 lakhs total. So if it is 6 lakhs, those two checks value is already paid.
But question is that matter.
The third check, whether it is there or not, that cannot be brought here.
But check is, I'm not coming, but 6 lakhs. Where is the evidence that he has paid the 6
That's what I want you to show me, that where from the tribunal, where from the trial court has come to this
It was
conclusion.
wrongly interpreted, my lord, because the cross
So that,
examination
come
was
to that'll end the issue, if that be so.
because if it's again I'm taking to the evidence, my lord.
Let us come back to
Because
page 28.
It is a fact that on 27/5/2000 I received a number 3 lakhs. That is in total he received. It is not that he separately received 3 lakhs.
No, just come to page 28.
28. Yes, my lord.
Now I see 1 to 3rd line, 28th second, third last paragraph. Now
On
I
this-
see
On this point,
and find that in his lengthwise cross-examination, he admitted that the accused paid him 3 lakhs only, for which he did not issue any money receipt.
but he,
We'll come back to the evidence. Then 65 on 22/5, Exhibit A. 25 in the account. 2,10,000 was paid by accused on 27/5/2009. And after filing of the complaint, another 50,000 was paid. So if we go by these admitted payments, accused had paid 6 lakhs only to the complainant. Now you come back to your evidence.
page 37, madam.
Where is it that that finding is from which part? Mr. Bhuya, where do I get that finding? That finding material,
Yeah, that is.
page 29. No, I got it, but he is drawing this conclusion from which evidence? Where do I get it?
Page 37, madam.
Oh, page 30. Sorry.
Mr. Roy, if you come to page 37, first line, it is a fact that on 27/5/2009, I received an amount of rupees 3 lakh and I did not issue any money receipt to that effect. So 3 lakh, no money receipt. 3 lakhs, 3 lakhs, no money receipt. Let us say that this is the 3 lakhs you have
Yes.
mentioned. We'll
Yeah.
come to that. Now you come to that payment of 3 lakhs at page 39.
Yes.
Here, there are 3 transactions. One is on 18/5, another one is in the bank on 25/5, and the third one is also a bank transaction through a check.
27.
Now, the opening statement in cross is that you have not issued any receipt for 3 lakhs.
Like in total,
I'm coming to that.
that is the catch, my lord.
I am coming to that. It is a fact that on 27/5 I received an amount of 3 lakhs and I did not issue any money receipt to that effect. Now you come to page 39. Exhibit A is on that day, 22/5. Exhibit A is on 22/5.
Yes.
So 22/5, then the next date is 25/5 and the third date is 27/5. And the amounts are not 3 lakhs on 27. It's 2,10,000. How do you reconcile this?
This total 3 lakh, my lord.
Where have you said that? Just show me one line.
No, no.
I'm allowing your application.
Evidence, lordship may see, if cross-examination itself, that he has paid this amount, my lord. First, that means, my lord,
Mr. Groy,
he
come to page 37.
yes.
It is a
When-
fact on 27, I received an amount of rupees 3 lakhs. If it was here, then we could have drawn a presumption that he is saying the cumulative amount received till 27.
That is
Now,
what.
now you read further. And I did not issue any money receipt to that effect. He has not
I'm
issued.
pretty sure, but that is the bank's,
No, you come to page 39 now.
39 years.
Opening paragraph. Exhibit A was issued on 22/5. In my exhibit A, I have written that receipt
Part
back.
payment, that is part 65,000.
That is, I'm saying,
Yes.
you say you have not even issued any certificate. Now here you have said 65.
No, that is different, my lord. So 65,000 plus I have other two checks. I have not issued any-
I'm not sure, but this evidence of yours, okay. Now, he had deposed before the court.
No,
You have not deposed.
I too, my lord. Yes.
Hmm.
My lord, section 17 of the Evidence Act. Statement, oral or document, it suggests to the inference initial relevant fact. What? That's the question.
That's a question.
Can you note that? He cannot have. My lord, multiple, my lord, story. That is. This. Notice with regard.
That we have seen.
Yeah, 41. Oh. And now they comes to the demand, my lord. My colleagues, colleagues. From paragraph. He said. Demand, can you see? Twice the amount of. Loan taken by you from the. Clients, not one, clients, hotel, clients, severally within 15 days from the day. The inception 3. My lord, 6 lakhs and one another person.
Okay, okay, Mr. Yeah. Let us say that these are two checks only. We'll limit it to them. And both the checks have a value of 3 lakhs, 3 lakhs. Now, here we find that on 18/5/2009, no, the evidence, 18/5/2009, you have returned 65,000 against Exhibit 1, right? You have not paid the balance. Then you continue to pay till 27/5/2009, amount of rupees 3 lakhs. Huh? No. Then on 27/5, we will go by the strict evidence. You pay another 3 lakhs. So you have extinguished your liability.
Absolutely.
Now you come to page 48. That is your reply. That with regard to the check number so-and-so, it is for your information that my client has already made part payment of the aforesaid checks. This is of 16/6. But on 27/5, you have made the full payment.
The interest part. With regard to this, and that's why.
Where is the interest?
My lord, what I am on, here the legal notice can say.
Mr. Bhuyan,
My lord, my lord. The inception, what is their case? Their case. And they projected their.
it cannot be, Mr. Bhuyan, let us read two together, so 48. That with further regard to the check number so-and-so, it is for your information that my client has already made part payment of the aforesaid checks, two checks,
Yes.
checks. And both the checks you have made part payments. And as such, my client was under the belief that on payment of so-and-so will return the checks, but after a shock, your client has, in spite of receipt of part payment, has deposited the aforesaid 2 checks in the bank. So if you have
Particular day.
on 16/6,
Yes, no. By then. The part payment has already been made. Legal notice is for 6 lakh, assuming there is no demand in the legal notice. Payment already made. So, in that view of the matter, he is not at the.
okay, we come to that.
My lord,
We'll come to that. We'll come to that.
one thing, my lord, I'll
I'm
appreciate
only
here.
trying
Because
to.
of the law, my lord. Law is changing. Law is this. A check I have issued it to my lord of 10 lakhs. If time before presenting the check, I returned him 5 lakhs.
Then he can't place that 10 lakh check.
Yes, he can with the endorsement.
That it's only for 5 lakhs.
Absolutely. Presentation of this check.
See, that 6
And
lakhs.
he-
No, I'm
he
or-
paid 6 lakhs, which-
Mr. Anand, Mr. Bhuya, I'm only trying to understand
Yes.
whether it is 3 lakhs plus breakup of 3 lakhs,
Yeah.
6 lakhs, or it is only 3 lakhs, the payment made.
Yeah.
And it is an interpretation because of the questioning in the cross-examination. We are trying to, the learned court below has come to a conclusion that is 6 lakhs. So it is only that, to that extent. I have the power that if I come to the conclusion, no, it is 3 lakhs, only balance receivable against those 2 check, I can pass orders in my
Yeah.
appellate jurisdiction, I can pass. I'm only to that extent. Now, if I come to para 2 says that you have made a part payment. If it was on 27/5/2009, you have paid 6 lakhs, there was no remaining payment to be made. Okay,
Father,
we'll
we got to
clarify
take
it. We'll
Because
clarify
legal
it.
notice has been dashed.
Uh.
Even in spite of making part payments, you are presenting the check.
Okay, he presented his check for, he was only entitled to 3 lakhs, basing on that, but he presented a check for 6 lakhs. We know that. I'm only to that extent. Whether we can limit it to 3 lakhs for him. Now,
You know?
I'm just trying to understand. Now you come to the next. Come to para 4 of your notice, of your reply. So what is that balance amount?
That balance amount.
No, I got it. 50,000, 50 rupees, you have put it in his account, but
Yes.
there is nothing. There is no demand. Because that goes beyond 6 lakhs.
Yes, that is.
Why?
That is because. That means he.
Where has he asked for that? No, forget the complaint. Where is the demand here?
And these, my lord.
Demand is only he can't go beyond the check amount.
Whatever it is.
He can't go beyond the check amount.
But even then, my lord, a complaint has been filed. That he needs 5%.
On
According to
16,
him, 50,000, 50.
Mr.
Let's leave it, my lord. From
Forget
that
it. 50,000, I have not even
Now-
touched it.
Now, what is the prosecution case? 6 lakhs.
6 lakhs. And
So,
he has,
3 lakhs has been paid.
Ah.
And that been paid.
one check goes.
Oh, and the legal notice that has been issued. Now. My reply. Come with a cock and bull story with the.
I'm not on that.
Now.
Forget
the
all those
whole
facts.
case is of 6 lakhs.
I am only seeing 3 checks.
Yeah.
One is gone.
One
2
is-
checks are there.
Yes.
Amount is 6 lakhs. First and foremost, the submission of the cross-examination first line that he received 3 lakhs he received.
Yeah.
And then the subsequent clarification
Yeah.
that these are the breakups of the 3 lakhs. He tries to project that these 2 pertain to the single I'm coming.
Yeah.
Mr. Bhuya, you are an expert in this line. Let me also try to catch up. So there are 3 lakhs. One is a breakup of 3 lakhs. Another one is 3 lakhs. You project this is 6 lakhs. He projects all those, both the transactions are the same one and it pertains to 3 lakhs only. So let us accept his contention for a time being. He issues a notice to you. He demands against 2 checks, which he could not have done because at least one was already paid. Because we are only with 3, 2. Now, you, in your reply, you say, I have paid a part of it. I have paid a part of it.
My lord reply, my lord will read it. I say whatever it is, I pay. But you are not entitled to 6 lakhs as claim or 6. That is my reply.
Part payment issued in spite of 2 checks. Now you come to para 4 of your reply.
Yes.
That my client is willing to pay the balance amount, 15 days. So this indicates that you are admitting here that out of this 6 lakhs, there is a part payment to be made. No.
Pay 50.
I'm sorry, mister. Here the interest question will not come.
No, my lord.
You cannot claim interest here. He cannot claim interest in the notice.
What I am on,
I got it.
yes.
But
So,
where is the indication that what you are saying is the balance amount? You have not spelt it out here.
that also. I have to.
So I can draw a presumption. I can draw a presumption here that you had at least is one check. One check.
No, my. Presumption, although. Legal notice.
You have not adduced any defense witness.
Because all are admitted in cross-examination. Case is.
Okay. Okay. You know how much you paid him? 6 lakhs.
50,000.
50 is not on 16.6. I'm only on the reply and the notice and the reply.
This payment is been made.
Made. Notice. What prevented you from writing a single line that not part payment, I have paid the full amount? I have cleared your full amount.
But it has been agreed upon. You has been asking. That too after filing of the.
Filing of the case, it's a different position altogether.
That-
As far as this court is concerned, I can't understand
None of-
what was
that-
transpiring in between you.
This is the complainant's demand.
Complainant's demand in the notice is that you pay the check amount, that
Yes.
much only.
Yes, complainant is for 6 lakhs.
Hmm.
Now, whether 6 lakhs has been paid prior to notice or not, a part payment has been made or not. And the exhibits.
But we'll consider that.
Yes.
We'll consider that.
Second question, that legal notice becomes bad in view of the fact that he's.
Mr. Bhuya, we'll consider that. Whether that while issuing the legal notice, he ought to have factored in the part payments made, which is an admitted position now. 3 lakhs or it is 6 lakhs, be that as it may, but something was paid, which would have negated the single check, one of the checks to be taken out, because we can't have the third check brought in.
Yes, yes.
Now, my
Yes.
question is whether it is 3 lakhs or 6 lakhs.
And it has been paid. And for that purpose, interest part, my lord, whatever it is, I have to pay you. Suppose in a legal notice, my lord, I write it down, that you are entitled to 6 lakhs, but I will not pay you. Now, in the cross-examination, I can show from the record, because it has to. The legal notice of law, it becomes a. The 9,81,000 legal notice time came before the court when the complaint was filed. Then evidence on affidavit, it came. That has to be tested. Now, legal notice we know is trial itself. But whether he at the filing of the case if any part, even 50 rupees from 6 lakhs or not.
That would have rendered the liability.
Absolutely.
We got it. But I am testing my own understanding.
Yes,
Why is these two paragraphs, 3 and 4 incorporated, 2 and 4 incorporated in your reply?
It is because maybe, my lord, to be very
Because your client may have not have disclosed this fact to you that there was payment already made.
hard to payment bin.
Because why I'm saying so?
Yes.
If this is the amount, then his claim is 9 lakh something. I'm not on that. So whether you are contemplating that 9 lakhs or you are contemplating 3 plus 3, 6 lakhs.
Why?
We'll examine.
Because his complaint by cannot have as inception is 6. The notice, legal notice itself is defective. Because there is no demand itself. For secondly, has been projected even that they are entitled legal notice, they receive a part of it, which is no.
In this case, there is no question of you bringing in any pleading? No,
No. So in a criminal case,
there is nothing.
nothing. So I can reverse the presumption.
The only thing the learned court below has gone is
Yes.
that it has taken the first line of the cross-examination and the subsequent clarification to be two distinct transactions. Mr. Roy would project that these are not two distinct transactions, it is one. 3 lakhs. Got it.
Court evidence. It has
It has appreciated. It has appreciated that in a sense that 3 plus 3, 6 lakhs.
and my lord, where comes this rest of the amount?
That we are
Rest
not
of the
concerned.
amount, if it is.
And we will not,
Exit-
Mr. Bhuya, we will not also hold Exhibit A to be not a part payment of 628467. We will hold it to be that only.
And
His
we-
subsequent clarification will not bring.
Suppose if I taken 10 lakhs and I repaid back. And I gave a reply that I will pay another 1 lakh to you. Is it the liabilities of 10 lakhs? I have paid him from the record by way of cross-examination. And my lord, the chart check, the bank witnesses has been examined. Chart check was never been presented.
It was not presented, that will not come into being.
Absolutely. And so if exhibit there is no case at all. And apart from that, even assuming, my lord, the law has been there, part payment has been made, and he has been claiming for. That's the law. Of this judgment, my are all admitted by the bank witnesses. I have proved the satisfaction of the trial court.
65, you have a
Yes.
Exhibit A, receipt from him. Then the other two, that is 25,000 and 210, these are bank transactions. No, 65 is a certificate, Exhibit A from him.
And my bank witnesses.
They have said about 210 and 25,000.
Absolutely. Now, this has been proved by the PW2 and what remains?
Okay, thank you.
These are the exhibits, my lord.
Mm.
Exhibit E. By way of.
What is the amount involved? 25,000 and 210.
Yes. 25,050 rupees.
And
And my lord.
2 lakh 10.
25,000, my lord.
Twenty-eight 8 2009. That is beyond. That is beyond. That is beyond.
That is the different.
That is different.
But these bank witnesses have been. My bank also, my lord.
You
The law
come
is
to
very
the
clear.
judgment of the my Lord Justice Chandrachud,
Yes,
para 30, second one,
yes.
subclause 2.
He has to be clear from his.
No,
what
no,
is the scheme.
just.
Of the Psalm. Part or whole. Admitted facts, payments were made, my lord.
Mr. Roy. This court,
The reverse burden, my lord, one more judgment I am.
Hmm.
NIX, my lord. Paragraph 30 again, my lord. To how I can discharge my life. Why, my lord is making a query with regard to, suppose 10 lakh says, I am saying, I have taken 100 crores from you and I will not return. Isn't it amongst the admission? Absolutely.
para 30.
Yes. correct.
The proviso appended to the section. Proviso.
What's the matter? Not a matter of either. Or any other. There's been a presumptions were there. Presumption that I have not been paid. Presumption basis. The part payment has been made and it's not a legal notice and subsequently come and raise it. That.
Okay, got it. Mr.
Say appeal against accused.
Roy, can you have 138, section 138 NI? Rest you have read, I have also understood something there, but B. Check has been presented to the bank within period of 6 months. Okay, the payee or the holder in due course, as the case may be, makes a demand for the payment of the said amount of money by giving a notice in writing to the drawer of the check. The said amount of money here means the check amount that is now judicially laid down. Within the drawer of the check fails to make payment of the said amount to the payee and to the holder in due course within 15 days. Explanation, I am on this. For the purpose of this section, debt or other liability means a legally enforceable debt or other liability. Now, we'll consider whether it is 3 lakhs or 6 lakhs. We have taken Mr. Bhuyan's view on that. We'll consider that.
Remember that, my lord, there is no cross-examination to that.
Fine, we'll consider that. Now, here there are 2 checks. You have received 3 lakhs. I'll say only 3 lakhs rupees. Right? Now, the materials that are on record, especially that first line and the page 39, that paragraph, says that you have received a part payment.
Against 67.
Against 67. 65,000 against 67. And the other 2 is not specifically issued against any checks. So we'll hold it to be either against 67 or against 68.
There is no cross, lots of people remember that.
But
There is no
one second, that deposition is yours.
Yes.
So there was a part payment made. Now your further deposition is that 22.5, he made 2,10,000. And on the same day, he issues you 3,45,000. Check. You say that, say, this was not issued on that day, this was issued on some other day. You say on 27.5, at least it was issued to you or given to you on a date prior to 27.5. So it cannot be 27.5. It was on a date prior to 27.5, say after 22.5. Someday it was given to you. You say that this was not returned by me because the debt against that was completed. It was returned because that was the only check I was carrying of Mr. Bhuya on that day. 1. 2. Now you have to show a legally enforceable debt on the date you issued the notice. Presumption to be drawn. Now, why was this things not brought in the notice?
Yes, I don't have to explain so many things.
No, you will have to
Notice-
explain your debt, your liability
Yes,
that you have received
Yes.
so much. Because why I'm
No,
saying
one-
so,
one
now
38
6
lakh.
lakhs is reduced to 3 lakhs. Even if I hold in your favor
Yes.
today, that okay, he had 2 checks. One will not go because of the beauty of the cross-examination of Mr. Bhuya. It became 6 lakhs. I'll not write that. I can't write that. But let us hold it that because of the beauty of the cross-examination, really a marvelous cross-examination, the man did not even know what he's saying. That's the mesmerizing effect, be that as it may. But even if we hold that, it is only 3 lakhs. Your part liability is done. Now, how can you utilize? Because
Lordship-
these 2
Lord-
checks,
Lordship
we
is-
will consider it as one now.
Lordship will see, Lordship is correctly said about the reply to the legal notice, my lord. It speaks, my lord. Because there is no explanation there, my lord, that
Everything will boil down to the evidence coming on record.
Yes.
These are just part
Very
and
simple.
parcel of the thing.
That's why, my lord, I projected the case because if your lordship read independently first line of the cross-examination, that taken as a 3 lakh has been. But how and what manner it is not there, my lord.
Because Mr. Roy, the problem here is that on 27/5/2009,
20 to 5.
27/5, the
27.
date is 27/5, you say you received 3 lakhs, whereas on 27/5 in cumulative you had received 3 lakhs
Yes.
and that is not there.
Yes, in
That
cumulative
is not
evidence,
there.
in cumulative evidence, and
That is
why-
not there.
That is,
Then
That
comes
is
the
why different
cumulative
dates.
breakup in page 39.
that's why different dates, my lord.
But Mr. J. Roy, learned counsel for the petition, also heard Mr. A. Bhuya, A.K. Bhuya, learned counsel for the respondent. Hearing, have heard the learned counsel for parties at length. Hearing remains inconclusive. Raised it to list this matter Thursday. Try to pass the order on that. But be careful when he is there crossing.
I was not there.
I know.
Lastly, we came, man.
You are now catching up, playing the game of catching up. Oh. Mr. Sharma. Before we ask Mr. Monto, the evidence of the postmortem doctor is there. The doctor who did the postmortem. But prior to his death, he had undergone a treatment in a PHC or in the medical college, wherever it is. Now, the evidence of the doctor is that this is due to antemortem injuries, blunt weapon, and coma. Now, when did he go into coma? It is not explained. Here, there are only 2 witnesses, 4 and 5. To them, one says that when I went to one is a brother, went to the, police station, He was sitting in a bench there. And on asking, he said that the accused, the petitioner herein had given him a blow. This is reiterated by PW5. Same thing. Now tell me, if he was in a condition to speak, if he was in a condition to depose, why his statement was not taken? Why the police could have done it? So that two statements, how do you examine? We'll hear Mr. Just find out your answer to that. Yes, Mr.
Correct. Only on the basis of the dying.
Correct, that is tentative.
No, that correct. The only 4 and 5,
4 and 5, nothing else.
nothing else, my lord. So if 4 and 5, my lord,
You can demolish, everything goes.
yes, my lord, your lordship kindly see.
Hmm.
Here my most important thing is that my lord GD&T.
Hmm.
GD&T was not exhibit. But it is in the part of the record, my lord, part of the case there.
Hmm.
So my lord, in GD&T, if your lordship go, my lord, he was brought to the police station by 4 persons.
Hmm.
Name
They
is
have
there.
not been examined.
They have not been examined, my lord. So if they would have been examined, my lord, so definitely, my lord, this is the first instance, my lord, that what condition he was there, whether he can make a dying declaration or any declaration is there, my lord. So that was not that these 4 persons were not examined. These persons were not examined, my lord.
Another
Now,
thing,
my lord, your
the
lordship kindly-
doctor who had first examined him and who had put the stitch mark.
they are not
Stitch,
examined.
they are not
He
examined.
also not examined. And a civil hospital. First, he was given to the field, then he was sent to the Dibrugarh hospital. First, it was in my lord,
Hmm.
Tinsukia.
Hmm.
So now, my lord, that is one of the my lord most vital aspect that was my lord not done. And the constable who has taken to the my lord hospital,
He was not
he
examined.
was not examined. So what type of my lord is my lord investigation done, my lord? Even that hammer that was also not examined, my lord. Now,
That was
my lord,
not-
another
but,
thing.
but Mr.
So that my lord corroborated by the doctors.
Okay.
Yes, only.
Now let us now that is one side of the story. That is your side of the story. Now let us see the cross you made. Have you ever endeavored
My
to
lord.
find out? Not
My
find
lord,
out.
cost part I have seen
Nothing.
only one.
Nothing is there.
One.
So 4 and 5 statement stands.
No, my lord. Your lordship kindly see why there are 161 statement twice. They are improving, my lord. He is a brother. If he is an independent one, my lord, I have nothing to say.
Oh, there is
But he is a
another one.
brother.
Another one.
No, other one is my lord, his friend. He
Friend.
came to the picture because of the my lord, this
Information.
PW4. PW4 and 5, they are my lord friends. PW4, your lordship kindly see first in the he 161. Why there are 161? Two version, my lord. First 161, he has not named anyone. And second, my lord, he has named me. That so when he was in police station, he speak to his brother. Why not police, my lord?
That
So
is what
that,
I'm-
my lord,
that is
normally,
the
my lord, what we are
only
doing-
place where I am now stuck. If the deceased was fully fit in a condition to speak,
then very much, my lord.
then
has to,
why his deposition? Now let us see the FIR for a minute.
my lord. Why, my lord? Prime there. May I read it, my lord?
You just read it.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি 4/9/2011 তাৰিখে পুৱা 9 মান বজাত মোৰ দাদা অশোক ভোৰ শাক পাচলি লৈ বজাৰ কৰিবলৈ গৈ থাকোঁতে ৰৈ থকা অৱস্থাত শিলুগুৰি বাস্তাত আগচি ধৰি দিগেন বিশ্বাস নামৰ যুৱকজনে মূৰত হাতুৰিয়ে মাৰি গুৰুতৰ জখম কৰে। লগে লগে আৰক্ষী যোগে তিনচুকীয়া অসামৰিক চিকিৎসালয়ত ভৰ্তি কৰাই যদিও গুৰুতৰ আঘাতপ্ৰাপ্ত হেতুকে উন্নত চিকিৎসাৰ বাবে ডিব্ৰুগড় মেডিকেল কলেজৰ ভৰ্তি কৰা হয়। গতিকে উক্ত দোষী ব্যক্তিজনৰ আইনগতভাৱে বিহিত ব্যৱস্থা ল'বলৈ প্ৰাৰ্থনা জনোৱা হ'ল। Then till then he has not died.
Oh, he died the next day,
Next day.
5/9.
So FIR was registered on 5th, my lord.
5th morning.
Incident of the 4th. But investigation started on the basis of the, my lord,
GDN.
GD number 49. But that GD&T, my lord, I find it in the case diary, not exhibited, my lord. That was the first information where, my lord, police
59, 59,
49,
59.
49, my lord.
What is that? What is there? Where is it?
That, my lord, your lordship kindly see what stated in 49 GD&T.
You have the record.
Probably record is there, my lord.
Sure, sure, sure. Deal with it. Agmat. Green color. GD entry 49. Yeah, at number
On
Oh,
4/11/930.
4/9/2011, Prai Sayanoboy.
Pua.
Pua Sayanobo. You have a copy?
No, my lord. I cannot, my lord. The case diary.
No, this is a case.
It was not supplied to me also because at the time of
No, you don't get the case diary copy. You don't get it. Dinesh Biswas.
and there is a note, and my lord, below, my lord, who are the 4 persons? Addition man, my lord.
Nothing with regard to the condition of the.
Dear my lord, nothing. And then, my lord, your lordship kindly see. Even, my lord, the prosecution not relied on also because it was not exhibited. Although this GD&T is very much required to exhibit, my lord, that was not exhibited.
The starting of the investigation is through that GD entry.
Just GD&T, my lord. So then, my lord, your lordship kindly see. Then 161, there are 2 is 161 statement, my lord.
You have not even comforted him with that.
My lord.
You have not even comforted him.
Correct, my lord. That is my weak point, my
not
lord.
going
If
to
the WS in my lord cost part,
Nothing is there.
nothing. No, my lord, that is because 161 is not given to me, my lord. Only, my lord, because your lordship kindly is the first one, my lord. No, why I am submitting, my lord, that it was the import version, second 61, my lord, which was supplied to me at the time of my lord framing of search.
So the records.
First one
Okay,
is
fine.
not, in first one, he has not named anyone. After date of the border, my lord, second 161 has been recorded, my lord. Because happen in the marketplace. If it is a marketplace, my lord, definitely, my lord, there are so many witnesses.
The people who accompanied him,
They are not exempt.
they are not exempt. Now let us see the evidence of the IO.
My lord. PW, my lord, 7.
Mr. Sharma. You have the. Take out the case diary and check up the times. When the 9:30 is the GD entry made, so maybe a little bit ahead of that, the People were brought. When was he sent to the hospital?
Next GD is there.
9:30.
Is there.
How much time was he there in the hospital? Police station, sorry. Huh? 30 minutes. Yes, Mr.
From the post part, my lord, your lordship kindly
Cross off the IO.
IO, my lord.
Mm.
Also 4 and 5 only, my lord. Only one pair, my lord. GD not exhibit, my lord. That is he clearly mentioned. Cross, my lord.
That part as to the capacity. If you come to PW4, seven lines from the top. পিছদিনা মই বাতৰি
পিছদিনা
কাম
মই বাৰীত
বাৰীত কাম কৰি থাকাতে অংগদ বিশ্বাস নামৰ মানুহজনে মোক খবৰ দিয়ে যে আসামী
ডিএনে মোৰ দাদা অশোক
মাতুলেৰে
মূৰত বিপুল দেৱ নামৰ এজন লোকৰ দোকানৰ সন্মুখত মাৰে। উক্ত
উক্ত
ঘটনা
ঘটনা
কথা শুনি লগে লগে মই ঘটনাস্থলী যাওঁ, কিন্তু
কিন্তু
ঘটনাস্থলীত
ঘটনাস্থলীত
দাদাক নাপালো।
তাক মই ইতিমধ্যে
দাদাক ইতিমধ্যে গুইজান আৰক্ষী চকীলৈ লৈ যাওঁ বুলি গম পাই তালৈ যাওঁ। দাদাক মই গুইজান আৰক্ষী চকীত দেখা পাওঁ। মই দাদাক ঘটনাৰ বিষয়ে সোধাত দিগেনে মাতুলেৰ মূৰত মাৰিলে বুলি কয়। আৰক্ষী চকীত আছামী দিগেনো আছিল। দাদাক চিকিৎসাৰ বাবে তিনিচুকীয়া চিভিল হস্পিটেলত অনা হয়। তাৰপিছত ডিব্ৰুগড় মেডিকেললৈ অনা হয়। ডিব্ৰুগড় মেডিকেলত ডিব্ৰুগড়ত পিছদিনা দাদাৰ মৃত্যু হয়। ঘটনাৰ বিষয়ে থানাত এখন লিখিত এজাহাৰ দিওঁ। থানাত এজাহাৰৰ ওচৰত মানুহ এজাহাৰ লিখা মানুহজনক মই চিনি এজাহাৰখন মোৰ কথাত লিখিছিল আৰু এজাহাৰখন লিখি উঠি মোক পঢ়া শুনাই নে নাই পঢ়ি দিছিলো পুলিচে ডিব্ৰুগড় মেডিকেলত দাদাৰ লাছটো পাইছিল আৰু কাগজ পত্ৰ বনাই দুখ পাইছিল পুলিচে বনোৱা কাগজত মই টিপ থৈ দিছিলো
Mr. If you come to the medical evidence, PW2, the opinion,
কমা
when did this coma set in? Whether it was immediate or
Or
after, or after some time in the hospital or no witness have. There was one more, that Guizan auto stand, who that
Yes.
was by,
PW6 মাইলত ষ্টেট
huh.
6 মাইলত হিষ্টৰী
Aman Bozat.
দেৱক এক্সামিন কৰা নাই না খুব কৰিছিল নেকি 1 and 2 declared hostile
Anna Phale Lui. Mr. Come to PW6.
আছামী দিগেন বিশ্বাসক
No,
চিনি পাওঁ।
that much okay. 1, 2, 3, 4th line. Tetia Moy.
এই ঠাইলৈ আগবাঢ়ি যাওঁ দেখো অশোক আৰু দিগেনক বহুত মানুহে থানাৰ ফালে লৈ গৈছে
So he went on his, he could went, he went
Why not?
properly. So he was in a position to make that statement. Now, if that be so, the condition of the patient being not shown to be in a position that he was not able to speak or he was not able to say anything, then what is the error in this judgment?
in the judgment my lord that was brought where from it cropped up PW4
4 and 5.
4 and 5 will first year of the who is the lost the FI
4.
No, because 4 is the brother of the my lord this is so 4 in 161 stand first when he was my lord police station he says because it was cropped up from first it was from his statement my lord because he lost the FI when he lost the FIR he was not died GDNT, my lord, when GDNT was made, my lord, on the basis of the GDNT, that investigation started, and that, my lord, in that, after that 161 statement was lost, first 161, my lord, which was not supplied to me, now it is in the record, my lord, in that, my lord, he has not named anyone. After death, my lord, he improved it. After death, that is why this doubt is created, my lord. After death, another 161.
But that not having been comforted,
Correct.
I cannot now take it up.
That is not confident because it was
Maybe whatever reason.
that I do not know because 161 first 161 statement was not supplied to me because only second one is my lord supplied
On
to
that
me.
basis, I cannot
So that is in
undo.
record.
I got it.
That is in the
But the
police
thing
document.
is, this evidence that there was a fight or something affray going on in the bazaar.
But in
These two people were involved. that is there from the evidence of the others.
Yeah.
But maybe assault is not there, but that these two were involved in some affray, that is, the other evidences are there.
Yes, my lord, that is from the event, my
So
lord.
now there being nothing on record to show that he was not in a position to speak, then what is the error? We can't just
No,
because he's an interested witness, we cannot say that his evidence
can-
is not credible.
Because in cost part 4,
Nothing is there. Nothing is there. A simple question that how did you ask? Because he could not speak.
Your lordship kindly see, he was sitting in the police station as per their statement, my lord. But not a police officer, any taking his IO, my lord, he could have taken his statement, my lord.
That is what,
That is not done.
what I asked the last time
That
also.
is not done. And the 4 person who brought them to the police station, my lord.
Nothing is, nobody is.
Nothing is there, my lord. And now your lordship kindly see another very important, my lord. Your lordship, why that prosecution, my lord, Leonard trial judge, my lord, heavily relied on the, my lord,
4 and 5.
4 and 5. So your lordship, what 313 put, my lord, your lordship, 313 is a very important piece of evidence, my lord.
That we'll have to
Here only 3 questions put, my lord. What question your lordship kindly see? Only 3.
Rajiv Kumar Deb, Bipul Deb, it's both are, the relevant question was put.
No, your lordship kindly see.
The
What
most relevant question was put.
No more. First, only 3 questions, my lord.
Forget PW1, forget PW3. Both are, I think, declared as hostile.
My lord.
Come to PW4, question number 3.
PW4 Nityananda was stated that he meet Ashok in the hospital. Not in the police station, my lord. Your lordship kindly see what he stated in the evidence, my lord.
The police station.
Police station. And what about, my lord, is it 4? What about 5? There's not
Mr. Sharma, reliance on 4 and 5 not possible. But PW1 is nothing.
Hostile.
Hostile.
So
PW1
what's the hostile?
one is
What's
also
the
hostile. One is also hostile.
1 and
In the middle, you will find declare hostile, then cross. At the instance of the prosecution, the witness is declared hostile.
4, 3, 1 and 4, 3.
Maybe because of the change in the, that will not go into. But the problem is here that you have not demonstrated that he was in a condition to speak. Because the opinion of the postmortem doctor is that death is because of coma. When the coma set in, nothing is there. Nothing is there. So that evidence, and secondly, the fact that you're not accepting Mr. Monto's thing that it's a interested witness, that we are not accepting. But the question remains, the people who took them, they were not examined, right? The condition of the dying declaration, otherwise it will be a dying declaration. But that condition of the petitioner, that he was in a position to speak, that is also not there. And this thing has not been said by anybody else. If it was said by an independent witness also, nobody has brought on record the condition of the. That much doubt, I think, will have to go in favor of. And in 313, these circumstances were not put to him. The question itself framed is wrong. 313 is a very important, it has a basis. Because he could have made this statement before the police also. The IO in his statement does not say the victim told me that he was assaulted by. Yes, what do you want to show? FIR. What? This also? Yeah, that 302, it was done after 2 months. That is not going to cause you any prejudice. Okay. Heard Mr. T.J. Mount, Learned Senior. So heard Mr. P. Sharma, Learned Additional Advocate General appearing for the state. Course of hearing. Heard public prosecutor. Heard the parties at length. However, hearing remains inconclusive. Registry to list this matter on Thursday. I'll pass the order on that. Any judgment?
Yes, my lord, the small synopsis is there, my lord, everything, including judgment. I'm sorry that I am unable to give the photostat copy of the my lord judgment.
No need.
Required, my
No,
lord.
no. No, I'll get it.
File. Now, including 315,
Importance. Thank you.
bibliography.
Yes, have you examined? What do you find?
My lord, identification of the
EIP was not there. Yes, madam. Light of the lamp. But madam, the factors leading to the apprehension of the accused, it's different versions, and you have not harmonized those versions. 1 year.
for minor offense. Just 19 years, my lord.
No, no, no. They were 50 meters away.
50 meters, yes, 56.
Husband is PW Tamburu. And the victim is,
W2, my lord.
and both of them the statements are contradictory. He says that after the incident, he raised a hue and cry. Accused left the place. She went out to inform the matter to her husband. She does not say about meeting her brother-in-law at that point of time, Ravi Rambur. But the husband says, having heard shout from, she rushed to his house and on being asked, so and so, so and so, so and so, so and so, so and so. When the accused was brought before his wife, came and informed him about the incident. In the cross again, he says, what is he doing now?
Not contacting, my lord.
Incident is of
2013, my
30.
lord. 13, my lord.
12 years. Where was the accused that was he in the compound itself or outside? If he was outside, how did the people catch him without even knowing his name? That is different.
Yes, yes.
That is different. That is not proved. You have not proved the. Well, no, that is not. That house he has seen. There is Ravi Rambur, brother-in-law. Respondent number DW 5. No. He heard the shout of the wife of his brother. He immediately went, found the accused was coming out of the house of his brother. Yes, what is it? Show me. PW 5. Yes.
Second last.
Hmm.
Parvat Govind.
Hmm? Huh. Huh. Read it. Parvat Goy? Okay. Show me. Heard Mr. G. Alap, Learned Counsel for Repetition, also heard. Okay, we'll pass this on after some time. There is some bail and all matters. Just pass. Give me, please. Wait, 17. Yes. Yes,
The last occasion we were,
you are supposed to give me a
Yes.
breakup.
my lord,
Have you given it to madam? Copy.
but I have taken. First page. There are only 2 pages. First page is the made by the CBI that I. The second part is my.
Assets held before check period, statement A, rupees 296,670. Statement B, 24 for expenditure during 25.
My calculation is
Okay, assets held during check period. Like 96, assets. Madam, I think you'll have to go through this once. Huh. Okay, ma'am. You can give it to me next date, but you can give it to me today only. Okay, then give me next day. Mr. J.C. Gugoi, Mr. Your name? You, learned counsel for the petitioner has punished a breakup of the income oblique expenditure statement of the petitioner during the prior to the check period and during the check period. So a copy thereof has also been furnished to the Learned Standing Council, CBI. So the Learned Standing Council, CBI submits that the matter be taken up on 28. 28 will be fine. 28/10/2025 for hearing, enabling her to examine the statement prepared by the petitioner, Learned Counsel for the petitioner. Prayer accepted. Registry to list this matter again on 28/10/2025. 28, tomorrow, sorry. 4/11/2025. Tuesday. $498A. Demand is there.
Their lordship as per PW1.
What happened to the marriage now? Gone or there?
For 1 year, 9 months. That's not with me.
I know, but after the filing of this case,
That instruction I don't have, lordship.
not reconciled.
I have not, lordship.
So what is that? Nothing is there. What is the punishment?
I'm a railway employee. The verge of retirement. Try to.
Okay. Welcome.
Otherwise, I have no option, lordship.
498A. Let us understand
Yes.
498A first.
Married, lordship. Husband or relative of husband of a woman subjecting her to cruelty. Whoever being the husband or a relative of husband of a woman subjects such women to cruelty shall be punished with imprisonment for a term which may extend to 3. Explanation. For the purpose of section cruelty, any willful conduct which is of such a nature as is likely to drive.
This is not attracted
It is
here.
not attack. Lordship,
B will be
will be attack. Lordship. Harassment of the women where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of failure to her or any person related to her to meet such demand, lordship. The backdrop of this explanation B, Lordship, yes, there is a settled position that here harassment, any wear and tear in the normal course of legal life may not amount to cruelty. There is some more would be required to attack this provision, Lordship. Lordship, settled position.
Fine. Now show me
We'll
from the
go-
evidence,
If we go to the evidence of PW1, Lordship,
the mother,
no, PW1 is the victim.
victim.
Her was lost by PW2,
That is it, mother.
mother. There are certain circumstances which in my favor and there are some circumstances which against me. Must tell, Lordship. For reading to that, I thought, Lordship, there are some negative aspect in that PW1 statement against me, Lordship. That there was a demand, torture, rolled out by the petitioner to that force a writing letter that his son does not belong to him. Third, she was drove out from the home. First on PW1.
What happened to the other cases?
Other cases, I got acquittal in 406 cases, Lordship. 5, Lordship. I am paying 1,500 per month to her.
Till today.
Today, maybe in it may be enhanced also, but that instruction I have not. But the cross of PW1, it is being at that point of time, Lordship.
He has not filed any divorce proceedings.
No, Lordship.
406 is what is still done.
For still on. I misappropriated her property and gold ornament, etc., which was an allegation that I have sold out her gold ornament. But in this case, I got acquitted. Was a positive.
What is the cross?
Cross is not very happily crossed, Lordship. Here is, Lordship.
The two witnesses.
There are, Lordship, total 9 witnesses, Lordship. Of that, 1 and 2 are important, rest are not so much important.
Read the cross of one.
Got it?
Bottom.
বৰ্তমান মোকৰ্দমাৰ বাহিৰে মই আৰু দুটা কেছ আসামীজনৰ ওপৰত দিছো আসামীজনৰ ওপৰত দিছো 406 ধাৰাৰ কেছত আসামী খালাস দিয়া হয় খুৰাকী মোকৰ্দমাত মই 2500 টকাকৈ খুৰাকী পাই আছো খুৰাকীৰ মোকৰ্দমাত মোৰ স্বামীয়ে মোৰ লগত কোনো সামাজিক বিয়া হোৱা নাই বুলি কৈছিল এই মোকৰ্দমাত আদালতে আমাৰ সামাজিক বিয়া প্ৰমাণিত হোৱা নাই বুলি ৰায় দিছিল খুৰাকীৰ মোকৰ্দমাত মোৰ স্বামীয়ে মই পলাশ গগৈ নামৰ এজন মানুহৰ পত্নী বুলি অভিযোগ কৰিছিলে খুৰাকী মোকৰ্দমাত মই বিয়া হোৱাৰ কোনো প্ৰমাণ এক্সিবিট কৰা নাছিলো মই নাজানো মোৰ দাদাৰ ওপৰত ফেক কাৰেন্সি বনোৱাৰ কেছ আছে নেকি মোৰ এগৰাকী পেহী চন্দ্ৰকান্ত দাসৰ মাকৰ ঘৰৰ ওচৰত থাকে আৰু মোৰ পেহীৰ ঘৰত মোৰ লগত চন্দ্ৰকান্ত দাসৰ চিনাকি হোৱাৰ পাছত চন্দ্ৰকান্ত দাসে ইয়াৰ প্ৰস্তাৱ দিয়ে সেইকাৰণে চন্দ্ৰকান্ত দাসৰ লগত মোৰ পৰিয়ালৰ মানুহৰ লগত চিনাকি হৈছিল that পেহী is PW6 Lordship জিতেন দাস মোৰ দাদা এইটো সত্য নহয় যে মোৰ দাদা জিতেন দাস ডিব্ৰুগড় জেলত আছিল চন্দ্ৰকান্ত দাসে ৰেলৱেত চাকৰি কৰে মই নাজানো চন্দ্ৰকান্ত দাসে মোৰ দাদাক জেলৰ পৰা ওলোৱাৰ কাৰণে সহায় কৰিছিল নে নাই এইটো সত্য নহয় যে চন্দ্ৰকান্ত দাসে মোৰ দাদাক জেলৰ পৰা ওলোৱাৰ কাৰণে উকিলৰ লগত যোগাযোগ কৰি আৰু টকা পইচা দি সহায় কৰিছিল নে নাই এইটো সত্য নহয় যে চন্দ্ৰকান্ত দাসে মোক বিয়াৰ প্ৰস্তাৱ দিয়াৰ পিছত মই বিবাহিতা বুলি গম পোৱাত আমাৰ ভিতৰত ডিসপিউট আৰম্ভ হয় আৰু তেতিয়া মোৰ ঘৰৰ মানুহে চন্দ্ৰকান্ত দাসক ঘৰত জোৰ জবৰদস্তি কৰি মোৰ তাত ৰাখি যায় আৰু তেনেকৈ অলপ দিন থকাৰ পিছত মই পুনৰ মোৰ ঘৰলৈ গুচি যাওঁ এইটো সত্য নহয় যে মোৰ কোৱা ধৰণে কোনো ঘটনা ঘটা নাই মোৰ স্বামীয়ে কোনো বস্তু টকা পইচা বিচৰা নাই আৰু মোৰ স্বামী আৰু তেওঁৰ পৰিয়ালৰ মানুহে মোক কোনো ধৰণৰ কৰা নাই আৰু মই মিছা অভিযোগ তেওঁলোকৰ ওপৰত দিছো
মই স্বামীৰ ঘৰত 1 বছৰ 9 মাহ মান আছিলোঁ। সেই সময়ছোৱাত মই পুলিচৰ ওচৰত কোনো ধৰণৰ অভিযোগ লৈ যোৱা নাছিলোঁ। চন্দ্ৰকান্ত দাসৰ পৰিয়ালটো ডাঙৰ। চন্দ্ৰকান্ত দাসৰ ঘৰত তেওঁৰ বিবাহিতা ভগ্নী বায়েক আহে আৰু তেওঁৰ ভাগিন এজনো আহে। আছামীৰ ভায়েক জোন দাস আহে আৰু জোন দাসৰ পত্নীও এটা ল'ৰাও আহে। This much.
Now come to the main chief.
Chief Lordship. আছামী চন্দ্ৰকান্ত দাস মোৰ স্বামী। বাকী আছামীবোৰ মোৰ পৰিয়ালৰ মানুহ, স্বামীৰ পৰিয়ালৰ মানুহ। 2007 চনৰ 1 নৱেম্বৰত আছামীৰ ওপৰত মই গোচৰ দিছোঁ। 1-3-2006 তাৰিখে আছামী চন্দ্ৰকান্তৰ লগত মোৰ সামাজিক বিয়া হয়। বিয়াৰ পিছত মই স্বামীৰ ঘৰত আহিলোঁ। বিয়াৰ 2-3 মাহ পিছতেই স্বামীয়ে পৰা 30,000 টকা, ফ্ৰিজ, বাইক আদি বিচাৰে আৰু মোক আনিবৰ বাবে মোৰ মাৰ ঘৰলৈ যাবলৈ কয়। মই মোৰ মাৰ ঘৰলৈ গৈ এই বিষয়ে জনাওঁ। কিন্তু মোৰ মাৰ আৰ্থিক অৱস্থা ভাল নোহোৱাৰ কাৰণে উক্ত বস্তুখিনি যোগাৰ কৰি দিব নোৱাৰিলে। মই তেতিয়া মোৰ স্বামীৰ ঘৰলৈ ঘূৰি আহোঁ। মোৰ স্বামীয়ে মোক ঘৰত সোমাব নিদিলে, কিন্তু মই জোৰ কৰি ঘৰত সোমালোঁ। তেতিয়া মোক আছামীগণে মাৰপিট কৰে। এই ঘটনাৰ 3 মাহৰ পিছত মই প্ৰেগনেণ্ট হ'লোঁ। তেতিয়া আছামীগণে মোক প্ৰেগনেঞ্চি গুচাব বুলি ক'লে। মই প্ৰেগনেঞ্চি নুগুচালোঁ। আছামীগণে মোক নানান ধৰণৰ অত্যাচাৰ কৰে। 4-2-7 চনত মোৰ ল'ৰা এটা সন্তানৰ জন্ম হ'ল। মেডিকেল কলেজত ল'ৰাৰ জন্ম হয়। ল'ৰাৰ জন্মৰ পিছত মই মোৰ স্বামীৰ ঘৰলৈ আহিলোঁ। তেতিয়া মোৰ স্বামীয়ে মোৰ আৰু সন্তানক কোনো যতন নকৰাত আমাক খুৱাব নিদিয়ে। মই মেডিকেল কলেজত থাকোঁতে মোৰ সোণৰ গহনাখিনি আছামীগণে বিকি দিয়ে। মই মোৰ মাৰ ঘৰলৈ যাব খুজিলে আছামীগণে মোক এটা কাগজত নিজ ইচ্ছাৰে মোৰ মাৰ ঘৰলৈ গৈ আছোঁ বুলি লিখিবলৈ কয় আৰু মোৰ বাচ্চাটো চন্দ্ৰকান্ত দাসৰ নহয় বুলি লিখি দিবলৈ কয়। মই কাগজত এই কথাবিলাক নিলিখিলোঁ আৰু আছামীগণৰ অত্যাচাৰ সহ্য কৰি থাকিলোঁ। মোৰ বাচ্চাটো 9 মাহ হওঁতে মোক মায়ে চাবলৈ গৈছিল। তেতিয়া মোৰ স্বামীয়ে কয় যে মই মোৰ মাৰ ঘৰৰ লগত কোনো সম্পৰ্ক নাৰাখোঁ বুলি লিখি দিব লাগিব আৰু মোক মোৰ স্বামীৰ ঘৰৰ মানুহে মোক যিমান সেইটো সহ্য কৰি থাকিম বুলি লিখি দিব লাগিব আৰু নহ'লে ঘৰৰ পৰা ওলাই যাব লাগিব। মই কাগজত লিখি নিদিয়াত আছামীগণে মোক ঘৰৰ পৰা ওলাই দিয়ে। মই মোৰ সন্তানক লৈ সন্তান আহি মৌখিকভাৱে ঘটনাৰ বিষয়ে থানাত আহি মৌখিকভাৱে ঘটনাৰ বিষয়ে জনালোঁ। পিছত মায়ে লিখিত এজাহাৰ দিয়ে। পুলিচে মোক ডাক্তৰী চিকিৎসা কৰায়। তদন্তকালত পুলিচে এই আদালতত মোৰ জবানবন্দী লিপিবদ্ধ কৰায়। প্ৰদৰ্শক 1 মোৰ আদালতৰ জবানবন্দী, প্ৰদৰ্শক 1 মোৰ was all along with me for those people. Then after allegation of torture, after Lordship, she gave birth a male child from my house in a medical college. No complaint before the police. One dispute arises from the court evidence.
Who is appearing for the R2? Nobody.
Nobody, Lordship. Cost also, Lordship.
Okay, let us see the conclusions.
It is from minor Lordship. There are some contradiction of PW.
You are Tonuja Das. No, the wife is Tonuja
Tonuja
Das.
Das. All the family members. The court, she deposed only by centered zeroed down to the petitioner only. That demand for PW1 30,000 fees scooty same time. As per mother, it was one after another. 30,000 demanded, could not meet, came back. Thereafter again fees and scooty. There's an apparent contradiction. High Lordship 1 and PW2 as all Lordship. No specific date of incident has been made, Lordship. That মোক অত্যাচাৰ কৰে।
when, how. What statement has been made, Lordship? Like me in this case. I being a railway employee.
Yes, Mr. Soma. That is there. But that is there. Now, the demand translated into a cruelty. What is the material? That old injury. And that too old one was there. But the thing is that she did not bring this dowry. For that, she was tortured. Okay. Heard Mr. P.P. Lana Council for the petition. Heard Mr. B. Sharma, addition for the state. Hearing concluded. And first up, parties have been heard at length. Hearing remains inconclusive. Friday. We are acquitting him.
Somehow, if Lordship, it was yes, Lordship, but on by the council who has present petitioner, perhaps this is an NI case, Lordship. They have, I have to take that representing the respond number 2.
Or not shown.
Name shown, but no one appearing.
Forget it. You are there.
Uh,
You are there.
That instruction I have to.
On the prayer of the Learning Council for the petitioner, registry to list this matter again on Thursday. No further adjournment shall be granted in the matter. In the office note dated 23/10/2025, service of notice upon the respondent number 2 is not complete. The registry to
Lordship will obtain it.
Mr. B. Sharma, Mr. B. Sharma to apprise this court with regard to the status of service of notice upon the respondent number 2. The registry to list this case again on Thursday? Friday. 31. Reflecting the name of Mr. M. Khan, Learned Counsel for the petitioner. Did he also? He'll get it. What is there? Along, he'll get it. Yes. What is your instruction? Have you served the notice? Have you served the notice upon the petitioner? 20 kiman 20, huh? No, jurisdictional PS by speed post. 1510, oh. A registry to list this matter again after 2 weeks, along with the report with regard to the status of service of notice upon the respondent number 2. So, we'll see on the next day. Or service of notice upon the petitioner, respondent number 2. Yes, Mr. Sharma, there was a stay of the proceedings and still the charge sheet has been filed. Why? You're not a party here. Party, huh? You're appearing for whom?
Yet to be served to respond number. The informant lordship.
So he has appeared.
He has appeared in 2019.
You're appearing in this case for the first time. Your name is not shown. A. Goel, B. Chaudhary, you're appearing for along with Mr. A. Goel. Your name? Huh? You're not there. Okay. Yes. See, there is a clear-cut interim direction by this court that further proceedings in the case Kokrajhar PS case number so-and-so shall remain suspended. But his allegation is that thereafter the charge sheet has been filed on 3/5/2025. Right? Okay, we'll see. Heard Mr. A. Bachchaji, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor appearing for the state, and Mr. P. Sarawgi, learned counsel representing the respondent number 2. Also, issue notice IA today, returnable 10/11/2025. Mr. B. Sharma accepts notice on behalf of the respondent number 1, while Mr. B. Sarawgi accepts notice on behalf of the respondent number 2. You want an extra copy of the petition, Mr. The learned counsel for the petitioner shall serve extra copy of the present interlocutory application upon the learned counsel for the respondents. Steps, copies be served within 2 working days from today. Also, the learned counsel for the respondents shall complete their instructions in the matter and make their submissions on the next date of listing. So, registered to list this matter on 10/11, na? 10/11. Yes. Kali rati padiya. Tomorrow morning. First item. But the parties at length. Hearing remains inconclusive. Registered to list this matter again. Budbar idea. On Wednesday. 30. 30. 30. Yeah. Asani. Registered to list this matter again on 30. Huh? For further hearing. I'll pass the order on that.
Rajmana.
To the decree.